Thank you, everyone. Welcome back. Our next item on the agenda is the discussion and possible action regarding Assembly Bill 2566, Wilson Healing Arts Counseling. Because this is a robust discussion, we are going to allow commentators from both the audience here in the building and our remote participants to have 3 minutes time to make their comments. So with that, Roseanne, the floor is yours.
All righty. So AB 2566 would establish California as a member state in the Interstate Counseling Compact. The compact permits a licensed professional counselor in member states to practice in other member states if they meet certain specified conditions. And the bill has a clause in it that it would only become operative upon the board voting in favor of joining the compact. And let me clarify what that means. That does not mean voting in favor of the bill necessarily. That means that the board would, if the bill became law, the board would have to have a meeting to specifically vote in favor of joining the compact. So under existing law, there are certain requirements to become a licensed professional counselor in California. And then there are also different processes that the board has for out-of-state licensees to become licensed here in this state. So to become a licensed professional clinical counselor in California, you need to have a 60 graduate or 90 quarter unit degree that's counseling or psychotherapy in content. It needs to be a master's or doctoral degree. There's 13 core content areas covering certain topics that must be completed, as well as other specified educational topics. LPCC licensees need to complete 3,000 post-degree supervised experience hours and pass the California Law and Ethics exam and the NCMHCE clinical exam. If you're an LPCC coming in from out of state currently, there is a streamlined license process that is a little bit relaxes some of the requirements for initial licensees. If you've been licensed in another state as an LPCC for at least the past 2 years. If that is the case, instead of looking at all of your past education and experience requirements piece by piece, the board will issue a license if your license has been unrestricted, no disciplinary action for the past 2 years. You have to have a qualifying master's or doctorate degree from an accredited school. You have to fingerprint, and you have to complete certain California-specific coursework. That's 12 hours of California law and ethics, 15 hours of California cultures, 7 hours of California-specific child abuse assessment and reporting. And then you need to pass a California law and ethics exam. So they don't need to repass a clinical exam or make sure that they have all of their 3,000 hours documented or anything like that. That's the streamlined way in for an out-of-state LPCC currently. There are also some ways for people who are in the military or military spouses who hold a license in another state. California will recognize their ability to practice here as an LPCC if they're licensed else in another state, if they have to relocate here due to military orders. So there's some allowances like that. And then we also, most recently, the board also allowed a temporary practice allowance for out-of-state licensees to practice here for less than 30 calendar days or less if they have a current client traveling here. So this bill does something a little bit different. It joins the compact, which would allow individuals licensed in other states to practice here if we're a member state, and then it would also allow our licensees, if we were a member state, to practice in other member states. The goal of the compact is to improve public access to mental health services. The compact, it defines very specific legal things, and the legal language has to be adopted is exactly the same in all of the member states. So the bill that you see today we can't ask for amendments for it, because what a compact is every state legislature that's in the compact that votes to join the compact has to adopt the exact same binding language. So here's some of the things that are in the compact. It provides that the practice of professional counseling occurs in the state where the client is located at the time of counseling. It creates a counseling, what's called the commission, and that's the national administrative body whose membership consists of all states that have entered the compact. It has a data system that serves as the official database of information about licensees, their continuing education, their exam, any investigations, adverse actions, things like that. So there's one kind of overarching data system that the states all have access to. It defines a licensed professional counselor as a counselor licensed by a member state, regardless of the title used in that member state, to independently assess, diagnose, and treat behavioral health conditions. It defines professional counseling as the assessment, diagnosis, and treatment of behavioral health conditions by one of these LPCCs. You're going to hear me refer to member state. Member state means a state that has enacted the compact. Home state means that's the licensee's primary state of residence, where they're based and where they've met the full licensing requirements. And a remote state means a state other than a home state where somebody is seeking a privilege to practice. A privilege to practice is a legal authorization that is considered for the purposes of the compact as equivalent to a license, and it permits the practice of professional counseling in a remote state. The compact tasks various parties with various responsibilities. So I'm going to talk next about state responsibilities and licensing responsibilities. So the states have particular responsibilities if they're going to even be eligible to join the compact. They of course have to license and regulate LPCCs. They have to require licensees to pass a nationally recognized exam. They have to either require a 60 semester or 90 quarter hour degree in counseling, or 60 semester hour or 90 quarter hours of graduate coursework. And that coursework needs to cover certain specific topic areas. They need to complete supervised experience and have a mechanism in place for receiving and investigating complaints. Member states need to do various things to participate in the compact. They have to participate in the data system. They have to notify the compact commission of any adverse action. They have to have a procedure for obtaining and considering the criminal history of an applicant for an initial privilege to practice, like via fingerprints from the FBI. They have to comply with the commission's rules, which are binding upon them. They must attend compact commission's meetings, things like that. So those are some of the state's responsibilities. Licensees in the compact also have responsibilities as well. They have to have a valid license in their home state with no restrictions or encumbrances in the past 2 years. They have to pay applicable fees for a state's privilege to practice, and they have to meet any continuing competence of their home state. So if the home state has CE, they would complete CE in the home state. They have to meet any jurisprudence requirements of a remote state where they're seeking a privilege to practice. So that means that if they're seeking a privilege to practice in California and California requires a law and ethics exam, California can do that. They can require that. And then licensees need to notify the commission of any adverse action against their license within 30 days. And any licensee providing services in a remote state under a privilege to practice there needs to follow the laws of the remote state that they're practicing in. So those are some of the licensees' responsibilities. I'm going to move on to talk about disciplinary action, because that's kind of another aspect of this that the board may wish to consider. So in terms of disciplinary action, a remote state with due process may remove a licensee's privilege to practice in the remote state for a specific time, or impose fines or any other necessary actions. If a home state license is encumbered, the licensee loses the privilege to practice in all remote states where they hold it until that encumbrance is over and 2 years have passed. Remote states can also have the authority to take adverse action against a licensee's privilege to practice in their particular state, and can hold investigations if they need to, and they're permitted to recover the costs of any of those investigations from the licensee. So that's kind of the disciplinary aspect. The Counseling Compact Commission itself has certain responsibilities. It's a joint agency. It provides each member state one delegate selected by either its licensing board, who's either a current board member or a board administrator. And then each delegate in the compact gets one vote regarding the adoption of the commission's rules and bylaws. It meets once annually. And so the commission has various powers, establishing bylaws, adopting rules, all of which are binding on member states, bringing and prosecuting legal proceedings, borrowing and utilizing personnel for services, things like that. All compact commission meetings need to be open to the public, and they have to have a public notice given. There's a process prescribed. They have a rulemaking process prescribed as well, which just includes a notice of proposed rulemaking, public comment, procedures for a hearing, things like that. The commission is permitted to levy and collect an annual assessment from each member state or impose fees to cover its budget. If they choose, the compact commission has noted at this time they're not choosing to do that. Member states are required to submit data to the system, and the compact commission needs to promptly notify members of states of adverse action taken against any licensee or applicant when data is submitted to the system about, per se, disciplinary action. And then the bill states that all laws in a member state that are in conflict with the compact are superseded, and that all lawful action of the commission are binding upon member states. So in terms of a little bit of information about the compact and where it is right now, as of this date, 34 states have officially joined the compact. And I've included in my analysis a link to a map of the states that have currently joined in case you're interested there. The commission is indicating that they hope to be getting, this is a brand new thing, so they're hoping to be issuing privileges to practice in member states by the end of 2024. They're just getting up and running, and they're kind of in the process of getting started and forming their data, creating their data system, and adopting rules and bylaws. So I'll point out certain things that may be of interest to the board. In terms of some concerns, there's a title discrepancy between the bill, licensed professional counselors, and the board's license type, licensed professional clinical counselors, that it's unclear if it's significant or not to staff. The bill defines professional counseling as the assessment, diagnosis, and treatment of behavioral health conditions by an LPCC, or an LPC, which is defined as a counselor licensed by a member state, regardless of title, to independently assess, diagnose, and treat behavioral health conditions. So regardless of title, California's been pretty specific about the title and the education that you need to very specifically have it be an LPCC, because there's a lot of different variations of LPCCs nationwide, such as rehabilitation counselors, things like that. That's come up a lot in the past 10 years as we've started to license LPCCs, especially at the beginning. So I don't know at this time if that's significant or not, but that's something that's worth raising. It raises the question, if you're not equivalent in the scope of experience, if you'd still be able to join the compact. So the counseling compact, in response to that, provides some explanation of the reasoning behind that in the document. And so I've included a link to that document where they kind of explain the reasoning behind their decision there. So that's one point that's worth bringing up. In terms of education, to qualify for an LPCC license, the board is really stringent in that it requires the qualifying doctor or master's degree to be a single integrated degree program that's counseling or psychotherapy and content, meaning you can't piece together a degree. It's got to be in that single integrated program. You can remediate a certain amount of coursework outside, but you have to have that one degree that's qualifying. This bill it appears to permit 60 semester or 90 quarter units of graduate coursework that's not necessarily gained in a completed master's degree in counseling, as long as that coursework is there. And the specific coursework topic areas that must be covered don't cover all of the board's 13 required core content areas. So it is possible that somebody may be able to come in and they maybe have been missing some coursework. In terms of the exam, the board currently accepts the NCMHCE exam as the clinical exam. This bill would also, according to they actually have regulations or bylaws adopted that would also allow acceptance of the certified rehabilitation counselor exam be accepted, and also the NCE exam. So that's a little bit broader than what we currently accept here. In terms of California and the environment here, when we did the license portability committee to adopt that streamlined licensed process that I talked about a little bit earlier for an out-of-state applicant if they've been licensed for 2 years, it was really important to the committee at that time to ensure that somebody who is licensed in another state have certain coursework under their belt that assured that they know about certain things. There's a 12-hour California law and ethics course that the committee decided to require, a California cultures course, which is 15 hours, and a child abuse reporting, because California has specific child abuse reporting laws, 7 hours there. And the committee chose to require those courses in addition to passing the California law and ethics exam for out-of-state applicants to really ensure that they were qualified or had some education to be able to practice competently in California's diverse and multicultural environment. You know, California has some very specific laws that aren't necessarily the same in other states. For example, with conversion therapy, that's prohibited for patients under 18. So the board really wanted to drive home that those things there needs to be awareness of that before practicing here. So that's why it was thought to be important. Under the compact, we couldn't require that specific coursework, although we could still require the California law and ethics exam to be passed. Let's see what else. In terms of the fiscal impact, it's really hard to estimate a fiscal impact. We don't know how many people would want to come to California. We expect that it would be a significant workload because there are a lot of counselors in other states that might, you know, California is in a big market. There's 30 million people here, and that we would think that there probably a lot of counselors that might like to practice here that maybe work in smaller markets. So right now, we have about, as of April, we had about 4,400 active LPCC licenses in the state and 4,700 total that are active, inactive, and delinquent. CalPIC cites that there's 162 LPCCs nationwide. The numbers kind of vary. I was trying to gather. It's kind of hard to piece together exactly how many people are out there that would qualify under this. I think 162 kind of jives with some of the others I've seen people trying to piece together, but we don't really have a definitive answer. We really don't know. So just food for thought. If there's 162,000 LPCCs nationwide, if 20% of those wanted to practice in California, that would be 32,000 people. If 5% of those people wanted to practice in California, that would be 8,100. So we're still looking at a fairly large population potentially coming in compared to what we have, which is, you know, has its pluses and minuses. That's, you know, more mental health providers. It's significantly more than our LPCC population. But there's a cost to the board, you know, of having staff to you know, have those people at the very least, they'd have to take a law and ethics exam probably. So there'd be some staff work there, you know, the workload that generates in terms of enforcement and licensing, answering questions, things like that. We would need to have we think a pretty significant amount of staff to staff this, staff the database to make sure it's up to date, attend these meetings and track all of the rules and regulations that the Compact Commission is in and being in compliance with that. So we do see a fiscal impact with this. The bill allows the board, as I alluded to earlier, to collect a fee for a privilege to practice. So we think that some of that, you know, would be offset with revenue, but we still need to be able to be granted the permission to hire the staff in order to do the workload. So that's one consideration too. The Compact Commission could vote to have members incur additional costs, they can levy a fee. They've indicated at this time they do not plan to do that, but they could change their mind in the future, but right now they're not doing it. A few other questions that this raises. The bill requires member states to comply with the Compact Commission's rules and actions that are binding. Each board gets one delegate on the commission who has one vote, regardless of the state's market share or number of licensees. There are some concerns that this could potentially affect the board's ability to act autonomously to accomplish its public protection mission. It's currently unclear whether the board could deny or place restrictions on a privilege to practice of an applicant with a past disciplinary action who qualifies via their home state. We have a certain, when we license individuals, you know, if they have past disciplinary action, you know, depending, we take a look at it and we may issue them a registration or a license, but we may have certain probationary conditions. If you know, if they have a long record of past DUIs or some other thing on the, so there's a little bit of a question of like, you know, in terms of consistency and continuity, if we would have that ability to do that with these particular individuals. And additionally, we have to comply with the compact's terms and rules. Those rules are still in the process of being established, so we can't provide all of them and what they are yet. If we were on the compact commission, we would get to have a vote in creating those rules, however, so there's kind of that way off. Other things that have been brought up in terms of the P&A committee, somebody asked a really interesting question about would these individuals be able to supervise associates? Currently, you have to have a California license to supervise California associates. It's unclear from the language of the bill if this would be allowed. The board would likely want to run regulations to answer this question, but legal counsel pointed out at the P&A meeting, it's not really clear from the language if we would have the authority to run regulations to answer this question. So that's another thing that should be considered. Although the board may wish to restrict supervisors to only California full license holders, there's language in the compact that states a privilege to practice is equivalent to a license. So that we really can't answer that question at this time. So I think that is pretty much everything. I've hit all the topic areas. The Policy and Advocacy Committee, we just had a discussion of the bill in April, but opted not to recommend a position. Staff is inclined at this point to recommend an opposed position. This would allow the Compact Commission more time to establish rules and begin operations. And over time, there should be greater clarity to some of the questions the bill doesn't address about how certain disciplinary issues are handled, how supervision is handled, things like that. So I will open it up for discussion now.
Thank you, Roseanne. I appreciate that. Do we have a motion from the board based on staff recommendations or something different?
Kelly Renner-Singer,
Kelly?
Kelly Renner-Singer, public member. I'd move to oppose the bill. And I'd also ask Roseanne if she could maybe reach out to Uniform Law Commission and see what they think.
Uniform Law Commission?
Yeah, California has a commission on uniform laws. It's the California Commission on Uniform Laws. Their job is to assess and move uniform laws to the legislature. So I'm sort of curious because this is kind of their wheelhouse as to what their position is on this.
Okay,
Yeah.
I can do that.
We have a
I'll second.
second
Dr. Annette Walker, Public Board Member.
discussion.
Nick Boyd, LPCC member. So this bill certainly has significant implications to the state of California by joining the compact currently for LPCC members directly. And I want to acknowledge and recognize that, you know, consumer protection is the primary focus of this board. And that there is some ambiguity, some questions that still remain in terms of this bill. And I also want to acknowledge and recognize that the median wait times for healthcare in some cases are 67 days for healthcare in the country. Those are national averages, about 67 days. A recent study that came out in the General Hospital of Psychiatry, 2023, found that about 63 days is the average wait time. So, this is an opportunity also for us to potentially have a seat at the table. And just maybe consider if California did join the compact, might there be an opportunity to inform some of that policy? Or if we do decide to wait, what the consequences might be down the road, certainly with the shortages that we have in our state and specifically within our state. So something to consider.
Thank you. Other board? Susan? Your microphone, Susan.
I just don't understand what the advantage is for California to do this. I know that Nick, that you are a licensed professional, or I think this would affect you personally.
Yeah, it would. And I want to make it very, very clear that I have reservations. I'm not saying that as written that I'm not concerned. That's not, so I want to make sure that's well understood. What I am saying is it's a tough position when we have a huge problem with access to care across the country, certainly within our state. I can't refer veterans anywhere for care in over 35 days. People are killing themselves at rates unprecedented. So what is the solution that we look for? We're small in numbers. I mean, we're nowhere near MFTs, certainly social workers. So we're a small fraction, but might this be an opportunity to help start to address that issue and also maybe have a seat at the table to inform some of the policies and to give us the things that maybe we would want. The alternative is that we wait. That's certainly what I think Roseanne mentioned, and we can continue down that path. But my question to the board would be, what would be the cost? So I think that's an important thing to consider.
Abigail?
Yeah, I just, I don't like that this board, right, would not be a partner in creating the regulations, right? And that we would have to just comply with their rules and actions, right? Like we wouldn't have a say or it's unclear. It says if the compact language grants the board the authority to run regulations related to the compact. It's unclear if the board could restrict or place conditions on privilege to placeholders supervising California registered associates. So we would just be, giving over, all the decision-making over to the compact. So I don't know if their decisions will be in the best interest of our consumers right now. And I do get that we, not just California, but right, the whole nation, right, is wanting more mental health providers. But I think it would be like a hasty decision to just be like, okay, just go for it. So I'm more in the favor of opposing this bill the way it's written until we have more say in the matter.
Thank you. Other comments from the board? I also have the same reservations, Abigail, about the oversight, but I also hear Nick's concern about how do we increase access. So I appreciate those comments. All right. Comments from our audience? We're going to give you 3 minutes.
Okay, great.
All right.
I'll try to talk quickly. GV Ayers, representing CalPIC, sponsors of the bill. Appreciate the opportunity to talk to you and your consideration and what's going on with this bill there. There are obviously, we understand there are vast access to care issues in the state and simply more patients that need care than there are mental health professionals to provide that care. This bill represents the single best opportunity to provide more feet on the ground in the state to provide mental health services. Because as was said, as Roseanne said, it can provide a great number of people. Also in that consideration, obviously cost is a consideration in that. If there were the numbers, the first numbers that she talked about, 20% of the national, and they were charged $50 for a registration fee, that would provide more than adequate of the number of the amount that was estimated, has been estimated in the appropriations analysis for costs. So the costs can be there. The cost can be there in that. In addition, AB 2566 provides greater continuity of care for counseling patients. In most cases, to practice in another state, a California LPCC must become licensed in that state. This is a barrier to an LPCC who has an ongoing professional relationship with the client, and the client goes out of state for school or work or vacation or moves to another state. In such cases, continuity of care can be greatly impacted, and the time and effort that the patient and the counselor have to put in to develop a trusting and productive professional relationship must be started over again there. This same dynamic is also found when a counselor from another state whose client travels or relocates to California. In order for any in-depth counseling to continue, the counselor must be become licensed in California. The person would have to seek a new appropriate licensed counselor in California. We believe that the Counseling Compact provides greater access to mental health care in California, removes barriers to practice without sacrificing public protection, helps address healthcare workforce shortages, allows California LPCCs to provide greater continuity of care to patients, provides seamless ability for military personnel and spouses who relocate to practice, and preserves, also would say concerning that, military personnel and spouse, when they leave the military, they lose that ability through the that's provided through the recent federal legislation. This preserves that ability for them to continue to practice there and that. We believe that preserves
15 seconds,
the
Jamie.
regulatory oversight of the board, and be glad to answer any questions that you may have.
Thank you.
Appreciate it. Thank you.
Before he leaves the podium, are there questions from the board? Justin.
Hi, Justin Huff. It seems like a lot of what this bill is trying to do is make sure that LPCCs can travel across state lines in order to have more portability in their license. Is that correct?
Yes.
Is there a reason to suspect? Let me back up. The idea of helping expand care in California then is predicated on the belief that there are more LPCCs trying to come into the state than leave the state. Is there a reason to suspect that that's true?
Yes, the reason to suspect it, 4,400 LPCCs in California, 162,000 across the country.
Do you want me to help out? So LPCCs, California was the last state to license LPCCs. It's much more predominant in other states where the reverse is generally true. It's flipped nationally. There are more MFTs in California where MFTs it exists to a lesser degree in other states. It's more typically you see LPCCs.
I guess that answers part of my question, which is that there are more LPCCs outside of California than there are in California. That seems in opposition to the many, many articles that I seem to see every week of people leaving the state. So I'm wondering if there's a clearer idea of how many LPCCs are actually trying to come into California, as opposed to just how many exist around the country.
We've talked with ACA, American Counseling Association. They don't have a number on that.
Okay. And to be clear, I think that I echo a lot of what I hear. I support this. I have reservations about how it's written, but I'm maybe a little bit hung up on the argument being proposed that this will expand care in California, as opposed to expand care elsewhere if people are leaving as opposed to entering.
It is, yeah, there are both sides to that issue.
Yeah, thank you.
I'll just add, yeah, we really tried to find, because we had to do a fiscal impact on this. And of course, the fiscal is predicated on how many people how many licensees do we expect want to come here? And there's just not, I mean, nobody knows. I was not able to find any reliable predictions, even really any great estimates of exactly how many LPCs exist nationwide, let alone how many want to come here, unfortunately.
Case is 172,000.
Well, it's there.
I'll send you the link to that.
JV, can you do me a favor and talk into the mic? It's
Pardon?
talking to the microphone,
Oh,
please.
okay.
Thank you.
I think because I can't hear, everybody else can. Sorry about that.
That's in line.
ACA says 172,000 nationwide, and I can send you the link to that.
It's 100 something. We asked Steve and I actually met with the director of the Compact Commission and asked him for an estimate. He was trying to piece something together, but the problem is he was trying to piece something together. It's state by state, you know, each state is estimating kind of differently. There's not data from some states. So there was nothing great that we could point to that's like, that's the number. And this is how many people are.
The ACA document gives state by state breakdown.
You can see that we
How
have
accurate it is, I'm not sure.
we have the small data of when we opened up the Path 8 for LPCCs, and since 2019, the numbers of coming in have nearly doubled, but it's still 341 last year.
Yeah,
So
it's not-
it's increasing, and I think it's going to increase this year, but it's
not huge, but it doesn't, I mean, it was just about the same time as COVID that came in. It's full licensure, so there is a cost, you know, full licensure cost and an exam to pass. Well, there would be an exam to pass, you know, they'd have to do L&E anyways, but yeah, we really don't know.
Any further questions? John?
Oh, no, actually.
Okay. We're okay. Thank you so much. Appreciate it.
I'm here for more questions if you have any
Absolutely.
hot ones.
Leah Brew, LPCC and counselor educator. Also was on the board for 8 years between 2012 and 2020. So I'm speaking from experience there also. And just as a reminder, we have a path for people to come into the state if they're moving here. So that already exists, and it has some strengths that this compact doesn't have. I am excited about the compact. I think it's too early for us to join. I have 4 major reasons. One is competence of licensees trained in other states, the increased workload and fiscal impact of the BBS, identity confusion based on different license types, and I'll get to that in a minute, and harm to California LPCC. So first of all, in terms of competence, a lot of other states aren't allowed to teach about diversity. They are allowed to discriminate against LGBTQIA communities. And I worry that someone, even though they took our law and ethics test here, could still do discriminatory work and harm consumers. And we won't know until they harm somebody, and until that somebody is willing to stand up to the board and say, hey, this was a horrible microaggression. And it's also to support Black and Brown communities and other communities. We have such ethnic diversity in California that isn't true in a lot of other states. And I'd like you to note, if you looked at the list of states that have joined so far, they're all pretty culturally conservative states. So they have very different values than we have. Many of the educational requirements, as Roseanne listed, are quite different. And so are the post-degree or associateship hours. And what happens is the person with the lowest amount of education and not meeting that curricular experience then shows evidence maybe that, hey, maybe we don't need to have 3,000 hours. We can have 1,000 hours, like what state was that? South Carolina. Or maybe we don't need sex therapy. Maybe we don't need to train psychopharmacology or some other specific areas. So we're going to have to reduce our standards to allow this compact to exist in the way that it is right now. The only way we can make up for some of those things is to put them in the law and ethics exam. So they'd have to really reconfigure it. And should we decide to pursue this, I think we need to immediately start changing the law and ethics exam to ensure that people who take it demonstrate cultural competence through practice and not through like multiple choice, it's multiple choice, questions that are just objective, yes, no, right, wrong, but rather vignettes that are more complicated. Not all states have a cohesive program.
15 seconds.
Oh, you're kidding. I haven't even gotten to number 2. Okay, BBS increased workload. You're going to have to manage all the licensees that are added. You're going to have to address all of the increase in people who get in trouble. Even if they're not in trouble in California, you're still going to have to look at them. In 2012, we tried to bring on more people. We had the money to cover the LPCC, but the governor said no more hiring. And I'm done.
Sorry, you're done.
Okay.
Thanks, Leah.
Good.
Oh, before any questions for Dr. Brew?
I have questions. Can you clarify your third and fourth points quickly?
Yes. One is the state of Florida, when they opened up their license to allow the compact, because you have to open up the whole license, the other professions came in and said everybody should be able to get an LPCC, and they have to be accredited. So if their program is accredited, social workers, MFTs, psychologists are also called counselors in Florida. And then in harm to BBS licensees, when I was in a meeting with people all over the country in other states, they charge about $80 a session. And the going rate here, that at least in Southern California, when I was looking for therapy this year, was about $250 a session. So if consumers find out that they can pay $80 for some licensee in other states, that takes away business from our people who need it because our cost of living is higher. So I think we should wait. I think we should pursue this once this license has existed or the compact is in action for 2 to 3 years and we collect data to understand the effect. Thank you.
Thank you, Dr. Brew.
Any other questions? Nope, just good. Okay. All right. Thank you. Any other comments from our audience here in the room? Okay. Any comments from our remote audience?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon or use the raise hand function. All right, seeing no requests for public comment, would you like me to close that Q&A panel?
Yes, thank you. All right, Christina, would you take the vote? Oh, sorry. Mr. Sovek, coming in at the end.
Thank you. I just wanted to gather information, hear a lot more, hear from stakeholders to understand some of the points of view that I may not understand because it's not my license. First question I have is about 499.199, which on yours is, I think, item 34. The way I read it, it says the state states that laws in a member state that are in conflict with the compact are superseded. So then if this compact decides that they are in favor of conversion therapy or gender exploratory therapy, which are damage to LGBTQ people in general, that would supersede our particular rules. Is that correct?
I understand. My understanding is that this compact and the commission's
rules would supersede your policy decisions in these areas.
Okay. So
That's not correct. So this doesn't supersede any state law. So our state laws are very explicit about that.
Mhm.
So nothing would supersede that, but maybe GV can speak to that better than I can, from my understanding.
Yes.
Just to make Sure.
If I may,
Yes.
GV Ayers representing CalPIC. The compact requires the licensee to practice in the state that they're providing the service in, according to the laws of the state they're providing the service in. So superseding laws does not supersede the practice in the state that the service is being provided in. So if you're talking about someone doing here.
So what does it supersede then?
Also, pardon?
What does it supersede then?
Yeah. So like if someone comes from, I don't know, I'll just pick a state, North Carolina or something, into this state, would they be subject to our laws governing the conversion therapy? That's what I'm talking about.
Yes, they are.
Where does it say that in this compact?
I don't
I'm
know
not seeing it. I'm
Yeah.
not seeing it. That's why.
There is, there is a couple of different interesting statements. So they have to, it says in one spot that they have to abide by the laws of the member state where they're practicing. But then it does say that the laws are superseded, and I don't.
They're in conflict with the compact or superseded to the extent of the conflict. So that's an ambiguity they perhaps need to address for this board to feel comfortable that that would not affect the policy of the state.
So
That's where I'm kind of, it's the people that are coming in also that I would want to know.
Because also
apply to them.
reflecting in this map and looking at a certain set of values that are held by different people all over the country. Right now, a majority of the compact is definitely culturally more conservative. And if each state has one vote in the compact and the compact decides that they are not in support of LGBTQ affirming care, which we're seeing all over the nation right now in state legislatures, then would that supersede? Because that's what this statement says, that the compact would vote to say, we do not support LGBTQ affirming care, and then that would supersede. That's what this statement says as I'm reading it. So I would need some clarification.
Kelly. And GB, one second. Kelly, go ahead.
So my initial reading was the same as Council Shields. And frankly, it doesn't really matter who's right or wrong. It does create a legal ambiguity, right? And that is more concerning than anything else. And I don't necessarily like issues with where we have a bunch of member states basically implanting delegates into a non-uniform law commission. This is essentially just a bunch of people who can then sort of act in a manner with force of law over our scope of authority. That is somewhat concerning.
Thank you. GB.
Roseanne, did you have any feedback on that as well?
Yeah,
I hear your brain buzzing from over here.
So I'm looking at 4999.199A and C, and I'm going to read them so you don't have to scramble to. So 4999.199A says a licensee providing professional counseling services in a remote state under a privilege to practice shall adhere to the laws and regulations, including scope of practice of the remote state. So that says to me that if conversion therapy is not permitted in California, somebody practicing here, regardless of where their home state license is, cannot do that. However, C then says any laws in a member state that are in conflict with the compact are superseded to the extent of the conflict. Now, I don't know if the laws of the compact would go as far as weighing in on something like conversion therapy or not. It could be that the compact, they're just going to get involved with main, like, overarching licensing issues, not down to the nuts and bolts. But to me, those two statements are in conflict. Ordinarily, if this was ordinary legislation, we would ask for a clarification amendment or we would ask the office to clarify, make that clear in the bill, but we can't do that because we can't ask for amendments. So GB, do you want to weigh in on that further?
Yeah. 499.173 says the commission, talking about the commission's rulemaking ability. And there's some concern that the commission could then be going in and overruling the member states. But there it says the commission shall adopt reasonable rules in order to effectively and efficiently achieve the purpose of the compact. Notwithstanding the foregoing, in the event the commission exercises its rulemaking authority in a manner beyond the scope of the purposes of the compact, the powers or the powers granted hereunto, then that action by the commission shall be invalid and have no force or effect. Really, the Interstate Commission's rulemaking authority must be expressed in the compact and is limited to the implementation of the compact, the administrative things there. It has nothing to do and does not at all impact and overthrow the scope of practice of member states.
Christie?
So my other concern goes a little farther as well, which is that the commission is the authority to set the rules. So let's just say that, compact doesn't say anything about conversion therapy, but they decide to adopt a rule about it. Then that would, all the member states are bound by the rules of the commission, even though the board has one vote. They could vote against it. The commission can enact a rule that says it's not unprofessional conduct to do conversion therapy. So I'm just looking at it I'm looking at it from a legal perspective, and I don't think it's reassuring to know that there's these statements that say that the commission controls, the rules are binding on all the states. We have one vote, and we can be disciplined for not complying with the rules of the commission. So that's a concern I have about not just the compact superseding the law, but that the commissions further delegated through an act of the state and the board voting for it to affirmatively allow them to set those professional standards and rule, which would be binding on this board. That's what I'm thinking about.
I believe that opinion is overreaching.
Thank you. Kelly?
So this is why I wanted Uniform Law Commission to take a look at it, right? Because it's a bunch of lawyers from different states, and the California Commission is all California lawyers who specifically look at uniform law regulations to see if they fit within the uniform law structure of California. It's almost premature for us to look at this, right? Because, we're kind of shooting on the fly here. Uniform Law Commission is, their job really is to recommend uniform laws to the legislature. And to the extent that we can support or object it, really it should be looked at by them first. So that's my point.
Thank you, Kelly. Wendy?
And not to beat the dead horse, but if we're going to start, there's a lot of things in here that we could start to pick apart, like let me see, I got to back up. In that same 173 section, if they're hearing on a proposed rule amendment, all persons wishing to be heard at the hearing shall notify the executive director of the commission or other designated member in writing of their desire to appear and testify at the hearing not less than 5 business days before the scheduled date of the hearing. So not only would people have to give notice in advance, they'd have to fly out of state. Our licensees would have to fly out of state to this commission and be approved to testify on behalf of a rule or amendment. So that kind of flies in the face of our public participation rules in California as well. So I think there's a lot of ways to pick this apart. And since we don't have the ability to make amendments, it's just problematic all around.
Thank you. Any further comments before we move? Did you have a final statement?
On the motion itself?
On the motion, just on the
public comment on the motion itself.
We've already had the public comment on the motion. I didn't want to know if you wanted to wrap up anything that was currently stated with the board.
Well, I would urge the board to not take a position on the bill and let this move forward. The board ultimately has a unique ability in this bill because the bill does not become effective unless the board takes an affirmative vote to join the compact. Even if the governor goes through and the governor signs the bill, it would not become effective until the board chooses to join the compact. So there's plenty of room for discussion, plenty of room for consideration on down on down the line.
Thank you. Appreciate that.
Thank you very much.
All right. We still have a motion on the table. So Steve? Oh, I'm sorry. No, we went to this was, yeah, we already did that part. And then John opened the discussion again because that's what John does. And we appreciate you for that, Mr. Zovek. All right, Christina, would you take the vote, please?
Yes. Dr. Annette Walker,
Yes.
Imran Singha. The motion is to oppose.
The motion is to oppose.
And
Yes.
Oppose.
it's to oppose and to reach out to the Uniform Law Commission.
Yeah.
Yes.
For
Yes.
feedback.
Susan Friedman,
Yes.
John Sovek,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
Justin Huft,
Yes.
Abigail Ortega,
Yes.
Dr. Nick Boyd,
No.
Eleanor Uribe.
I'm going to abstain.
Motion carries.
Thank you. Item number 26, which is the discussion and possible action regarding Assembly Bill 2651, will not be discussed today as it is met its demise in the Senate and Assembly Appropriations Committee. So we'll move on to item number 27, which is the discussion and possible action regarding Assembly Bill 2862, Gibson licensees African-American applicants, Roseanne?
Thanks, Chris. So this particular bill would require boards within DCA to prioritize applications from African-American applicants, especially those who are descended from a person enslaved in the United States. So under current law, there are certain reasons that a DCA board may expedite the initial licensure process for certain applicants. Right now in the law, DCA boards are required to expedite the initial license process for applicants who are honorably discharged members of the U.S. Armed Forces or are spouses of a active armed forces military assigned to duty in California. DCA boards are also required to expedite the license process for individuals who can demonstrate that they are admitted to the U.S. as a refugee or have been granted asylum or a special immigrant visa. The Medical Board of California is currently required to give priority review status to applicants who can demonstrate they intend to practice in a medically underserved area or population. And certain boards, Medical Board, Osteopathic Medical Board, Registered Nursing and Physician's Assistants, must expedite the license process for applicants who demonstrate they intend to provide abortions within their scope of practice. And so this board would require DCA to prioritize African-American applicants seeking licenses, especially those who are descended from a person enslaved in the U.S. And it would have a sunset date of January 1, 2029. The author states that they are proposing this bill to alleviate internal barriers and deficiencies from African Americans who have experienced, who have been disadvantaged because of experience descending from enslaved persons. So some technical considerations on this bill. It's unclear how the bill doesn't spell out how the board would verify whether an applicant is African-American and how it would determine whether an applicant is descended from a person who is enslaved. For example, somebody might ask how they prove this. And so it would be nice to have something spelled out for consistency, especially across all DCA boards, on how that is what is acceptable documentation or proof of that. And for that reason, staff is recommending an opposed unless amended position on the bill, requesting amendments that clearly define this criteria that they must provide in order to qualify, because staff is not doesn't have the ability to make that determination of yes or no without knowing what information to consider. That's similar to an opposed unless amended position that the Respiratory Care Board of California has taken. They asked for some language so that they did not have to come up with a policy on how you actually prove that, what is sufficient proof. So I'll open it up for discussion.
Thank you, Roseanne. Is there a motion from the board based on staff recommendations or something different? Can you make a motion? I'm just
Well,
kidding.
no,
No, go ahead,
I
Christine.
just
Go.
want to make sure, because it might inform the motion,
Sure.
that I just want to give
course.
some another issue to consider. I'm kind of going to address the elephant in the room, which is the constitutional issue that I think is presented here. So one of the concerns I think the board should potentially address, depending on what position you want to take, is the constitutional issue of the Equal Protection Clause, because it's been raised by the Pacific Legal Foundation in opposition to this bill. They're sort of signaling that there could be a legal challenge. So depending on where you fall on the policy question, if you're in support of it, I think there's some difficulties with the way it's currently drafted in the bill from a constitutional perspective. So just for a quick primer on the constitutional issue, I'm reading from a recent Attorney General opinion on an analysis of the Equal Protection Clause. And the U.S. Constitution provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. As the Supreme Court has stated, a core purpose of the Equal Protection Clause is to do away with all governmentally imposed discrimination based on race. Under a U.S. Supreme Court precedent, all racial classifications imposed by a state must be analyzed under strict scrutiny. As the Supreme Court has explained, strict scrutiny is the most rigorous and exacting standard of constitutional review. First, a court asks whether the racial classification is used to further compelling governmental interests. If so, then the court asks whether the government's use of the race criteria is narrowly tailored, meaning necessary to achieve that interest. So one of the things I'm not seeing, and I do see when there is an important public policy issue, is they usually have declarative statements in the bill about the public policy they're trying to achieve. What is the compelling governmental interest from a factual perspective? They talk about this reparations task force report, that there's evidence. Well, let's show our work in the bill of the evidence you're talking about. And then there's no analysis of why this particular method is the narrowly tailored to achieve the objective. So that second prong is really important. We have to meet both prongs for it to be constitutional, because there is a lawful discrimination and there's unlawful. So of course we want to go in the lawful direction, because otherwise it can be challenged and as unconstitutional. And so my recommendation would be to ask the author to address those two prongs in declarative statements in the bill, so that, you know, if it does pass into law, you have a defensible legal position. Because at the end of the day, if this goes into law and you get sued, you're the ones that are going to pay for the litigation. The licensees kind of will, because they pay for the funding, but you know, it's going to cost the board. In my experience, constitutional matters are expensive litigation possibilities. So any event, I just wanted to lay that out there as a consideration for possibly asking for that in the amendment, if you're interested in the position that's being proposed by staff, or even a support if amended. I mean, I think amendments would be necessary to help defend the policy, which I don't think has been done so far, from what I can see in the bill.
Justin.
I motion to support, if amended, to include more discussion on compelling government interest and how this is a narrowly tailored law.
Bill?
Anything about, what about the other issues that Roseanne was talking about, like clarification of the evidence needed to determine whether someone is descended? Because that is a clarity problem as well for the board to implement. Would you be willing to add that as a possible amendment too? Or
I am not concerned about that, but if you think that that is,
well, I mean,
for this to pass, then
I think that in order for the staff to implement, because we're going to have to do rules on it, we're going to have to know what evidence we're going to ask for in order to make sure that we're properly implementing. So none of us seems to know what that would look like. So since they know their policy and they understand where they're going, they might have information that could inform in terms of exact statements in the proposed
I
legislation.
guess my concern is, I hear that and I agree. My concern is that around the country, attempts to try and get people to show evidence of being descendants from slaves have largely failed because people are not able to provide that documentation. So it seems like it's helping in name only if people are not actually able to meet that standard. We have on this board before allowed people to self-attest to a variety of different things. I'm not sure that I find it compelling that this needs a separate standard of evidence.
So one second, Eleanor, we'll get right to you.
I actually am trying to find out who's talking. There was a woman's voice and I don't know who that was. I've been trying to get attention.
This is Christy Shields, counsel for the
Okay,
board. I had
okay.
one that was to give you the
Thank you.
background on the
Thank you.
constitutional
It's helpful.
standard.
Appreciate it.
Sorry if I didn't say my name, I apologize.
It's okay. So Justin, your motion is to support with amendments, specifically with the amendments that Christie was.
Address the governmental interest and whether how it's narrowly tailored to
That's
address
correct.
the governmental interest.
But not to include the staff recommended amendments to define the criteria for an applicant must meet and verify information that they must provide in order to qualify for expedited licensure.
That's correct.
Okay. Do we have a second?
You have a second. Dr. Walker, Public.
Dr. Walker. Dr. Walker seconds. Do we have discussion from the board?
Yes. I'll go ahead and
Dr.
start.
Walker.
Thank you, sir. Dr. Annette Walker, Public Board Member. I'm going to just tame my passion here for this, as some of us have to do when we're very close to the issue. So I want to bring my rational mind to the conversation here. There's a lot to grasp. There's a lot to also unpack here. Yes, ma'am, I will. Thank you. There's a lot to unpack here, but if we just look at the facts here, my first question would be to staff. Can you share with me under existing law in the memo under number 3, how the refugees are demonstrating? I'm sorry, let me get to that point. DCA requires DCA boards to expedite the licensure process for applicants who can demonstrate that they have been admitted to the U.S. as a refugee, have been granted asylum, and who hold a special immigration visa. Do we have an idea of how they're?
Yes, the
demonstrating that?
DCA there's a very specific document that they have to present. And there's instructions on DCA's website for what document that is.
So there's somewhat of an example, a standard. Someone has already kind of started this work, because I too may not agree that what is proposed here as far as following the Department of Justice reparations. I don't even know what you would call that. That clause right there. Yeah, the text there. I don't know if that's the best way for anyone to demonstrate what they're asking for here. So this is why the motion set forth. I second that, because I don't think that really fits this criteria. Okay, so my next question would be, and that's addressing the author's intent. Okay, do we have enough information to take a position on this? I'm so glad that the motion on the table is something other than opposed, because I don't think we have enough information to take that stance. So that's not on the table right now. So I just wanted to make those comments, and thank you for answering my question.
Thank you, Annette. Any other comments from the board?
There was
Christy.
Christy mentioned that there's not in the bill, they didn't write out the research. So you're saying part of the amendment would be to add more as to the why?
Yeah, I don't know if you've seen this before, but in legislation, they will put in uncodified declarative statements of public policy and the rational, or in this case, the compelling governmental interest. And that involves usually factual statements of, evidence that they mentioned kind of in passing in the committee analyses. But I think that should be spelled out because the standard is so high to withstand judicial scrutiny. We need that evidence to support the policy that's being put forward, which, Pacific Legal Foundation has indicated, they believe is challengeable. So they're signaling to us that they've identified this issue. So we should respond by doing more work to prepare for that potential judicial attack. And so I've been in this department for 24 years and I've been through constitutional challenges. And I can tell you that this wouldn't meet the standard to help us defend that governmental interest. And I think they need to put more work into it. And they have a 1,000-page report. There's got to be something in there they can draw from to add to the legislation to support the interest and to explain that second part's important, that it's tailored to achieve that objective. They haven't connected the dots, so to speak, on how this would achieve the objective of remediating whatever the harm is they have articulated in that report. Again, you have to show your work from a constitutional perspective in order for it to pass the strict scrutiny test. Otherwise, we're just passing a law that's going to eventually be invalidated.
Yeah.
So I think that's why I'm saying send it back, ask them to put the work in, and that way we have some assurances that we have a legally defensible position.
And then what are your thoughts on what Justin said about allowing people to self-identify and us taking,
well,
as far as your argument for if we got.
Yeah, I guess I'm a little concerned about, how are we going to ensure there isn't fraud in the process if there's no documentation? People might all just say they are, and we would never know because honestly, we're not allowed to by law ask for race. It's illegal in California to ask for someone's race on an application. That's one thing that the bill doesn't even address is the Government Code Section 8310 says you can't ask for it. So we have no kind of roadmap of how to implement something like that. And that's why staff are looking for some guidance because we would have to adopt a rule. But again, we don't know where the line should be drawn on that. So it'd be easier to implement for us if they actually specified the proof. That way we don't have to hold up our licensing process or our rulemaking process in implementing it because we don't know how to implement it other than self-certification, which again, like I said, yes, it's expedient and all, but how do you prevent people from lying about it just to get advantage in the licensure process?
Like, yeah, for me, it's more of like not thinking about people coming in with those intentions, but more of like, how can we make it easier for both sides, right? So like, we can think of like a model for that is, because I wouldn't even know where to look for. I can't think of who manages that or what agency would have that information. Like,
I think the other issue
that's
is,
just,
how do we make sure the people who are entitled actually get the benefit and ones that don't get it? That's the other side of it too.
Yeah,
You want to make sure you're remediating the issue by getting that benefit to the people that qualify.
Yeah, so that's not a constitutional issue. That's more of like making the process as easy as possible for both sides. Because I'm listening that, things are that there's going to be more honest and yeah, I'm sure there will be a few people, right? But it's not like a big, I don't know. I'm not as concerned about that. Okay.
Thank you, Abigail.
Oh,
Ju-
I did have one last thing. So why are we strong to like oppose versus approve unless amended? Why do we choose oppose versus approve? The recommendation. No, I know that, but I'm curious about how come that was the initial recommendation?
I think all the other boards have done that. There's been the board you mentioned and the Board of Barbering and Cosmetology. A couple other boards have taken that position because they want to make sure that their licensure processes are not actually slowed down because they have to figure out how to implement this. And so they put a large fiscals. I don't know if you read the fiscal analyses in here, but they put big fiscals on over $1 million to implement this bill because of the clarity issue. So if you resolve the clarity issue, you remove the fiscal issue. And so I think they were saying, unless the fiscal is removed, we oppose the bill. That was their position. So that's probably why the staff thought it would be consistent with other boards in the department's position, but you're free to make your own decision, of course, on policy. So
Thank you.
Justin.
Huft, I also want to note, and I appreciate deeply the legal counsel that we are getting in the feedback. I also want to note that historically the fear of false positives, that someone who doesn't deserve this might benefit, has been used to stonewall queer and trans progression forward, women's progression forward, certainly in the Black and brown communities. And I personally feel deeply disinterested in having a conversation about, well, what if some small percentage of people have a faster application, though we have been asking for years to get faster applications anyways. That seems like, if that's the holdup, that's a strange place to draw a line in the sand. If we are committed to racial equity, I am not terribly interested in conversations about what if people who self-certify in a way that's fraudulent, because I think that is largely detracting from the larger steps forward that we're trying to make.
Thank you. Kelly.
So, I will say I do agree with Council's point about a legislative declaratory statement which addresses compelling interest narrowly tailored. That is the law, all right? And if we want to have this regulation shielded from potential attacks as good as possible, you really shouldn't. To some extent, I'm somewhat frustrated with the author that he kind of threw this very important issue out there with kind of a bare bones regulation. I am less concerned with the proof, and here's why. Big deal, right? The Indian Child Welfare Act has been going on for 30 years. We don't ask for someone to say, we would like proof positive that you are a descendant of an Indian tribe. No, it's reason to know, and that kicks in all of those powerful, compelling interest, narrowly tailored protections. And that happens all the time. And Justin is right. Traditionally, when you have non-traditional applicants entering into a sphere or a space where they are not traditionally recognized, the response of the institution is often to say, you don't belong here. Prove to us that you belong here. And I get that, from you have to prove to us that you're a descendant of slavery. My God, do you think they have a resume? It seems somewhat silly. So I would support Board Member Huff's regulation, Board Member Huff's motion.
Thank you. Comments from our audience? Comments from our remote participants?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon or use the raise hand function. And it looks like we have a request from Kathy Atkins. Kathy, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you. This is Kathy Atkins from CAMPT. CAMPT has not taken a position on this bill yet as well. We are also currently assessing it for a potential position. I guess in testimony, I'm asking a question, as we considered as well, of what impact this bill has on licensees as a whole as to processing. As I said, we're struggling with the merit behind the bill, which is there. And at the same time, what is the harm to those who are waiting to get their license? As I noted, we get so many calls to our legal line, and the number one call related to BBS is processing timelines and delays. And I know Steve and his team are working so hard to improve that, but it is hard to talk to our members who are losing jobs because, you know, they don't get their license in time, or they're, you know, they're struggling out there. And so I'm curious what the board or BBS feel these kinds of bills, not this particular one, but these kinds of bills, what the impact is, you know, similar to the CE concerns CAMPT has. There's other groups that are asking for the same. You know, there's a bill before DCA for gender affirming care. There's one, I don't know if I apologize, I forget if the BBS is looking at it today, related to marginalized communities. A year or two ago, there was one for military, and they all have merit, but if there's too many, it seems to defeat the initial purpose.
15 seconds.
Again, this isn't an opinion or a comment. It's actually a question as we assess this for CAMP's position. Thank you.
Thank you.
All right, this is the moderator. It appears there's no further requests. Would you like me to close that Q&A panel?
Yes, thank you, moderator. All right, Christina, will you take the vote?
Yes. Dr. Nick Boyd?
Christina, can you repeat the motion on the floor, please? This is Eleanor reading.
I know that there's amendment. Can't replace that amendment, but.
The motion on the floor, Eleanor, is to support with amendments. The specific amendments we're looking at is proof of constitutional
compelling government interest in narrowly tailored focus.
So the motion was to support the bill if amended to add declaratory statements that demonstrate a compelling governmental interest and that the interest protected is by this bill, that the solution is narrowly tailored to meet that objective. So those are the two constitutional things that, you know, I gave you an overview of that we have to meet to have the law be successful.
good. Okay, thank you. Christina.
Dr. Nick Boyd?
Yes.
Abigail Ortega?
Yes.
Justin Huff?
Yes.
Chris Jones?
No.
Wendy Strack? Thinking about it.
Yes, please. Sorry.
John Sovik?
Yes.
Susan Friedman?
Yes.
Kelly Ranasinga?
Yes.
Dr. Annette Walker?
Yes.
Eleanor Uribe?
Yes.
Motion carries.
Thank you. I need to ask if we need a break. We've been about an hour and a half since lunch. If we want 10 minutes, or if you guys want to continue 10 minutes. Okay, we'll take 10 minutes. So we'll see you back at 2:22. Definitely the marathon today, not the sprint. All right. Everyone back. Perfect. Excellent. Thank you so much. Welcome back. We are moving on to agenda item number 28, which is discussion and possible action regarding Senate Bill 26, Umberg, Mental Health Professions Care Scholarship Program. Roseanne.
SB 26 would create a scholarship program in order to incentivize people seeking licensure as a marriage and family therapist, clinical social worker, professional clinical counselor, or psychologist to work in a county behavioral health agency in support of the CARE Act. Under existing law that was recently created, it creates the Community Assistance Recovery and Empowerment Act, the CARE Act. And the intent is to provide a process for earlier intervention for individuals with certain untreated mental health disorders. It creates also a health professions education fund within HCAI, which we've discussed earlier today with their scholarship and loan repayment programs, for purposes of providing scholarships and loans to students from underrepresented groups who are pursuing careers in the health professions. So we have, and I've mentioned earlier, we have a licensed mental health service provider education program through HCI AI that our licensees participate in, and they pay an additional $20 biennial renewal fee as part of their license renewal, which is used to support that loan repayment program. So in this particular bill, it would create an annual scholarship for the purpose of increasing culturally competent LMFTs, LCSWs, and LPCCs and psychologists who are needed to work for county behavioral health agencies to implement the CARE Act. In order to qualify for the scholarship, an applicant needs to be pursuing a degree that meets the state's requirements for licensure, and they need to agree to work for a county behavioral health agency in support of the CARE Act for at least 3 years upon being licensed. The scholarship program does not have a funding source specified yet. It simply states that it is operative upon appropriation by the legislature. The author's office notes in their fact sheet for the bill that with the recent establishment of the CARE Act and the CARE Court program, that there is going to be a need for more behavioral health professionals to work in county behavioral health agencies to support the program. The Policy and Advocacy Committee discussed this bill in April. It opted not to recommend a position. It directed staff, though, to seek additional information from the author's office about the estimated scholarships amounts and the allowable work settings. So I reached out to the author's office. They indicated that they don't necessarily have answers for that yet. They're waiting to see if the bill is funded in the budget before making any decision on scholarship amounts. So we still don't quite have that answer. Regarding the work settings questions, so they indicated the positions would be as an LMFT, LPCC, LCSW, or psychologist at a county behavioral health agencies. And they noted that it would be up to the Department of Healthcare Services to determine what type of work site choices recipients would be given. So that those decisions will likely be made if and when the bill passes, either through policy determinations or via regulations through DCHS. And so staff recommends at this point the board consider taking a support position on the bill.
Do we have a motion from any of our board members?
I'll make a motion to support the bill, even though I am not optimistic about its prospects.
And John, you look like you want to second?
I'll second.
Excellent. Do we have any discussion? Nick?
I just want to, I'm in favor of the motion. I would like, though, for consideration to potentially make an amendment that DCA review that all counties are including LPCCs currently in their systems for hiring. As it stands now, I know that there's a number of counties across the state that have not met the current legal requirement to do that and have such turned away folks because they're unwilling to take the time to update their archaic systems to be inclusive of LPCCs in the law as exists today. So that would be my ask.
Board Member Strack, would you be open to amending your motion to include to support with an amendment? She says yes.
Yes.
Would you be willing to second that, John?
Question. This may be to you. If it's a legal standard that they're not qualifying for, how is this particular bill supposed to address that? Because this bill isn't about the legal standards of hiring LPCCs.
Right. And so I'm not sure. I mean, you could maybe do would agree with that. And I think that maybe you could do a support with a letter of concern about that maybe being covered. But I think that the point of the bill is to just address these the scholarship program itself, not the.
But I think inherently you would be excluding people, right?
So, right, but where would we do the amendment? That's what I'm trying to figure out.
It's a great question. I'm not a lawyer.
We could do support and then I could provide technical, I could have a conversation with the author's office about the concern. You know, whether or not sometimes you know, that if it's already a heavy lift, which this might be a heavy lift because of funding, sometimes they may or may not be willing to take that on. So the board has to consider, would you still support the bill if not? But
Right.
so it's kind of two separate issues. Do you support it only if they do this, or if we reach out and say, we'd like you to do this too, and they say, no, we can't do that for some reason, would we still want to support the bill as is?
Yes, Eleanor.
Okay. And I had,
Oh, sorry, Eleanor.
I had a clarifying question.
Hold on one second, Eleanor. John?
He's not sure if he wants to second that amendment to the motion.
Extra amendment, I don't think I can second over.
Well, we can,
If someone else would like to second, I'm going to withdraw my second.
we can also amend the motion
Right.
if it would behoove Wendy.
Yeah, I was like, can we amend the motion then to support and then just have Roseanne express concerns about that issue? Not necessarily requesting an amendment, just noting it's an issue that needs to be addressed.
We can do that, Roseanne?
Provide the technical support.
Can you use a microphone?
It would be support and provide the technical support.
Okay. Say it again.
So it would be, so the motion would be support, and then separately staff would provide technical support to express the concern that not all counties currently include LPCCs. And so the board would really like to see, but the support's not contingent on some sort of a requirement that LPCCs ensure they are included so that they are being fully utilized.
Would that be a place to start?
Yes, and I think that if what we're saying is if we're supporting the bill, we're supporting it, that we're going to propose this recommendation to look at it, but that if they say we don't care, it's going to go forward anyway.
Yeah.
So that would be where I would say no, I don't
Okay.
support that.
And then you can reflect that in your vote. So John, we're back to the original.
Can I get clarification? This is
Oh,
Eleanor.
sorry. Yes, Eleanor, go ahead.
So I had a question because it says psychologist. Is that, since we're over jurisdiction of educational psychologists, are they referring to educational or is it?
No,
regular?
I don't believe so because we have a different path to licensure than the rest of the licensees. Is that my correct read on
Yes.
it? Right? They're
Yes,
talking about
that's
clinical
correct.
psychologists,
They're talking about psychologists licensed by the psychology board in this case.
the other psychologists, not the better psychologists. Teasing, that's a joke. Sorry, that's a 2:30 joke. I apologize. I forget I'm on microphone. It's live. It's not great. Somebody take me off this board. So Wendy, we're back to your motion was to support the bill with a letter from BBS to
Technical support from staff to advise on the author about this issue.
right. That's fine. John, you are good to second.
I would
that?
be honored to second that
Wonderful.
motion.
Any other discussion from the board? Before I get myself into more trouble?
I think there
Eleanor.
needs to be, sorry, this is Eleanor Uribe. I think there needs to be a little bit more clarification as to, what was it? I don't have it in front of me. Basically, this is for like the pathway, because it kind of generally says that are going into careers. But so this is, I would say, aimed at people probably that are students, which is when they really need the money, or maybe right after. But there has to be some type of maybe a little bit clearer distinctions, so that they know it's a social work degree, it's a sociology, or social work or counseling degree. So my suggestion is to make that a little bit clearer.
Okay, thank you. We can maybe add that into the memo.
So the applicants for the scholarship shall meet all the following requirements. They are pursuing a degree program that meets the requirements for licensure as a marriage and family therapist, clinical social worker, professional clinical counselor, or psychologist pursuant to the laws of the state. So From my read, that it's clear that the person needs to be in a qualifying master's degree program in order to qualify for the scholarship.
I would agree with that interpretation. This is Christy Shields.
Are you okay, Eleanor? Did you see what they're talking about?
I heard that. I don't know, for me, I mean, at this point right now, I mean, if that's enough for everybody to understand, that's fine. But I definitely would like, if it does become available for all these people, to take advantage of it. So,
All right,
yes.
thank you. Our audience has arrived.
Thank you. Ben Caldwell, MFT. I would respectfully request the board reject the present motion and instead take an oppose unless amended position. Tethering a new graduate student to 3 years of employment years later upon licensure in an underpaid setting is not only not especially helpful, it is potentially exploitive of graduate students' immediate financial needs. This is not a scholarship program. That title is misleading. It's a forgivable loan with strict terms for avoiding having the money later clawed back. The 3-year work commitment may mean that a quote unquote scholarship recipient must forego $50,000 or $100,000 or more in potential income to meet the work commitment for what could be a $10,000 or $20,000 scholarship. That amount is not yet set. That would be quite an interest rate. I request that the board take an oppose unless amended position with the suggested amendments that the author shorten the work commitment to 1 year and more clearly describe this program as the forgivable loan that it is. Thank you.
Thank you, Ben. Any other comments from our audience members?
GV Ayers representing CalPIC. Thank you for looking at this bill and appreciate we are supportive of this concept. We're supportive of LPCCs being included across the board. I like what Mr. Boyd has suggested as far as an amendment, but I understand that probably this is not the place for it in this bill, although I love that sentiment there as well. So thank you.
Thank you. You sure?
Just in response to what Ben Caldwell said, this is Leah Brew, LPCC. There's already a precedent set for this. If you work for a state or county organization for, I think it's 10 years, you can have student loans waived, and that's like a federal law, I think. I know that many of my students who, or I should say alumni who have come back have used that. And while they didn't get to go into private practice, they were employed with health insurance and an adequate salary for those years, and removing that loan was super helpful. So I'm not sure, I did not carefully look at how much this quote unquote scholarship is, but there is precedence for it, and it's been super helpful for my alumni.
Thank you.
I'll just add, we did try to find out the scholarship amount. It's not determined yet. It's dependent on funding. So they basically said, we don't know yet.
All right. Eleanor, you had another comment before we move on to the.
Yeah, as I remembered, I think Ben triggered my thought. So just keep in mind that the Council on Social Work Education is requiring the universities as of 2025 to do 1 year, have a 1 year kind of advanced standing program. So, you know, that's just one thing to think of. I don't know how long this funding will be for. I know there is a child welfare stipend that currently is at $25,000 a year, and it has kind of similar. It's like 2 years of payment. I guess so it's $50,000 that there would be 2-year repayment. Anyway, so, and that's to promote people in child welfare. So it sounds kind of similar. So I as far as me, I think the payback, as long as, you know, they get the regular pay, I don't think there's, you know, I think there's some fairness there. So.
Thank you. Thank you, Eleanor. Do we have any comments from our remote participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please use the Q&A icon or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close that Q&A panel?
Yes, thank you, moderator. Christina, would you take the vote?
Dr. Annette Walker,
Yes.
Kelly Ronasinger,
Yes.
Susan Friedman,
Yes.
John Sovek,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
Justin Huft,
Yes.
Abigail Ortega,
Yes.
Dr. Nick Boyd,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
Thank you, Christina. Next on the agenda is item number 29, discussion and possible recommendation regarding Senate Bill 294. Weiner, healthcare coverage, independent medical review. Roseanne?
Thanks, Chris. So this bill seeks to address an issue. Under current law, consumers have a right to request an independent medical review of their health insurance, finding that a requested healthcare service is not medically necessary. So in order to do this, the consumer would first they would file a grievance with their plan, and then undergo a 30-day review process that would happen. At that point, if the outcome is not what the consumer was hoping for, the consumer can then decide to request an independent medical review. So that's the current process. What this bill is doing is it's seeking to reduce barriers associated with that process. If a mental health treatment or substance use disorder is denied based on a lack of medical necessity for a child or young adult up to age 26. So if mental health treatment or substance use disorder was denied for medical necessity for somebody under age 26, it would make the grievance process for non-life-threatening conditions automatic rather than consumer initiated. And then if the grievance is upheld or still pending after a certain time frame, it must automatically within 24 hours be submitted to the independent medical review system. So the consumer doesn't have to decide to actually initiate it. It just automatically happens. For life-threatening conditions, the grievance process is not required, and the case must automatically be submitted to go into the independent medical review system. So that's what it is proposing. Just a little bit more about existing law. I've explained the basics, but every healthcare plan must establish and maintain a grievance system. It's managed through the Department of Managed Healthcare for review. And usually there's a 30-day process for submitting a 30-day grievance process, then they submit to the department for the review. The independent medical review system is something that can request, and that is independent of the state or the insurance plans. Healthcare plans and disability insurance are required to prominently display information currently on the right of an enrollee. You're insured to request an independent medical review in things like insurance contracts, evidence of coverage forms, in denial letters, things like that. And then if an independent medical review, which is an independent organization that's doing these, once they make their determination and issue a written decision, then that's binding on the health plan and insurer. Whatever is decided, the health plan has to abide by that. So the author's office, and the reason they're running this bill is they note that the state's independent medical review process is available, but the consumers must initiate the review, which poses certain barriers. They note that there's language barriers, health literacy, and demanding jobs might prevent some parents from filing independent medical reviews, and that further causes mental health access inequities. We didn't talk about this bill at the Policy and Advocacy Committee because we ran out of time, frankly, in April. But staff recommends that the board consider supporting this bill. The board analyzed a very similar bill to this bill last year. It was SB 238, also by Senator Weiner. at the August 2023 meeting, the board took a support position on that particular bill. The provisions of SB 238, which did not move forward, actually have now been moved into this bill, but there are some changes that were made. The most notable change is that an automatic grievance submittal for denials for life-threatening conditions so basically you have to do an automatic grievance submittal before the automatic independent review process begun. So they've just been negotiating different things, and this is what it's ended up looking like. But staff is recommending support because it seems to be seeking to reduce some barriers and move forward in equitable access to mental health treatment. So I'll open it up for discussion.
Thank you. Sorry, thank you, Roseanne. Do we have a motion from the board based on staff recommendations or something different from it?
John Sovek, I move to support.
Excellent. Do we have a second?
Justin Huft, second.
Perfect. Thank you, Justin. Thank you, John. Any discussion from the board? John.
Quick question, Roseanne. Do we know why it specifically excludes Medi-Cal?
I don't know why specifically, but typically the Medi-Cal is different and has more complications. So it's not uncommon to see certain bills like this that are seeking to reduce sort of barriers and things not include Medi-Cal, probably because it's a whole other topic they don't want to get into. They just want to try to further this first. What can I clear up one thing? Did I hear the motion correct was to support? Okay.
Any other discussion from the board? Discussion from our audience? How about discussion from our remote audience?
This is the moderator. At the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, you can either click the button or use the raise hand icon. All right, seeing no requests, would you like me to close that Q&A option?
Thank you. All right, Christina, take the vote, please.
Can I ask
Dr.
one-
Annette Walker.
Can I ask one question? I'm so sorry.
Yep, Nick, sure.
Just to clarify for me to know, is there any sort of like concern for, I know there's been a lot of insurance providers, insurance companies in the state of California, not so much on the health side, kind of, increasing their fees, stuff like that. Has there been, when the bill was proposed, like conversations about that? Not that that's going to change my vote, but I'm just curious, like, is there any potential consequence for that? Like, is this an added burden at the insurers, giving them another reason just to raise the cost for healthcare now even more than they already are?
In terms of some of the opposition, I don't recall seeing like an actual cost concern. There were some concerns about, the consumer would have to eventually consent to the information being sent over and things like that. But, I don't,
Yeah.
it's possible that that's been raised, but
Okay.
overall, I mean, I think that you can look at the support and opposition and kind of glean from that what you will.
Okay. All right. Sorry. Yeah, I did. Thanks.
I had a question.
Eleanor, go ahead.
Eleanor Levy. Okay, I was just checking. So if it goes to this independent medical review, is that someone they get to choose or just somebody who randomly? I was just curious on the process.
It's an independent organization contracted by DHCS, I believe, that makes the decision. So it's not state affiliated, or the consumer doesn't get to choose it. It's not state affiliated or health plan affiliated. It's an independent decision maker.
Right, thank you.
All right, Christina?
Dr. Annette Walker.
Yes.
Kelly Ronisinger.
Yes.
Suzanne Friedman.
Yes.
John Sovek.
Yes.
Wendy Strack.
Yes.
Chris Jones.
Yes.
Justin Huft.
Yes.
Abigail Ortega.
Yes.
Dr. Nick Boyd.
Yes.
Eleanor Uribe.
Yes.
Motion carries.
Thank you. Next on the agenda is item number 30, discussion and possible action regarding Senate Bill 402 Wahab, involuntary commitment. Roseanne.
SB 402 proposes to include licensed mental health professionals including mental health professionals who are not county providers, in the types of individuals who may be designated by a county to take somebody into a 72-hour custody if there is probable cause that they are a danger to themselves or others or are gravely disabled as a result of a mental health disorder. So under existing law, there are specific procedures that are outlined to take a person into a custody for one of these 72-hour holds. And it specifies that certain persons can do this. A peace officer, professional person in charge of a facility designated by a county, designated members of a mobile crisis team, and there's a few others on the list. The purpose of that hold is for assessment, evaluation, and crisis intervention. And each individual county behavioral health director is able to develop their own procedures for their particular county's designation and training of professionals who may take somebody into custody for a 72-hour hold pursuant to Section 5150. So each county has the ability to do it slightly differently if they want, however they want to do it within, of course, certain guidelines. So this particular bill would define a licensed mental health professional as basically a psychiatrist, a psychologist, an LCSW, an LMFT, or an LPCC who has completed all required supervised clinical experience and who is designated by the county. That particular type of person could do a 5150 hold. And the bill specifies that a licensed mental health professional does not need to be direct staff of the county or contracted by the county. The author's office states that this intent here is to expand the mental health professionals who may be permitted to take place 5150 holds to non-county mental health providers. They note that the decision does not always include the active involvement of mental health experts. Many counties restrict these designated persons to those employed by or contracted by mental behavioral health facilities, and this limits the ability of mental health professionals in private practices to support their clients in crisis. Currently, 5150 initiations are limited to peace officers and county designated individuals, so it just empowers clinicians at community-based organizations who build trust with individuals in the community who are suffering with a mental health disorder. So just one thing that I thought was interesting of the bill that I wanted to point out, I don't think that it necessarily needs clarification, but I think clarification would be helpful. The bill defines a licensed mental health professional as a psychiatrist, psychologist, LCSW, LPCC, LMFT, who has completed all required supervised experience and who is designated by the county. And I called the author's office and asked them what exactly they mean by completed all required supervised clinical experience, because all of our licensees are required to have 3,000 hours of experience or they won't be licensed. And I said, does that mean our experience that's required is by the board or experience required by the county? And they indicated experience required by the board. So I don't think that's really necessary, because by definition, if you're a licensed MFT, you have your required supervised experience. But it certainly doesn't, if that's their intent, which they say it is, it doesn't hurt anything being in there. It's just not the most concise, but they seem to want that language in there. So arguments in support and opposition for this bill. There's numerous supporters and opponents for this bill that make a wide variety of seemingly valid arguments. So there were so many and they were interesting. So I included a link to the most recent analysis, which is the Senate floor analysis that outlines some of those arguments in detail. Just kind of to summarize, supporters tend to state that law enforcement involvement is currently needed to be able to be admitted for psychiatric care. And they note that police encounters are dangerous for individuals in crisis, and that the determination for an involuntary hold is better done by somebody who has a relationship with the individual in crisis. Opponents expressed concerns that the enforcement of the bill would still require law enforcement of involvement, because that often it's the only way to get somebody to go to the hospital if they don't want to go. They state that if a person is willing to go to the hospital, they should be encouraged to do so voluntarily, as voluntary treatment is more likely successful. They also express concerns on what happens if the police officer and the mental health professional disagree. And this could be traumatizing to a person, and it could discourage someone from seeking mental health services. The Policy and Advocacy Committee discussed this bill in April. It opted not to recommend a position to the board, but it directed staff to reach out to the office to ask if they would also be willing to include LEP license types in the list of mental health professionals who can do 5150 holds. The author's office indicated that for this particular bill, they believe it's important to keep the focus on treatment of adults, which is what it's doing right now. And they noted that involuntary treatment of children is covered in a different code section, and expanding that would expand the bill's language. They did express openness to potentially looking at that in the future if the board was interested in doing that, but they did not want to do that as part of this bill. So that was their answer there. Staff is recommending the board consider taking a support position on this bill.
I have great concern that they're not including LEPs on this bill. And I understand that their intent is for adults. And so I'm going to not make a motion and allow my fellow board members to do so, because I don't want to hold up important work for other people. Eleanor, do you have a quote? Would you like to make a motion?
Actually, can I ask a comment first, or do we have to make a motion first?
Do you want?
Can I?
Sure, you can ask a question.
Okay. Okay, so I wanted to know, or can I just make a statement? Okay, so I believe as far as in federal, like let's say VA, our therapists can do 5150 holds. I would say generally not all therapists know how to do a 51 hold, and then there's also the risks of, you know, like they were mentioning, you might need a peace officer to take the person and also deal with whatever, if there's resistance. So my suggestion is if there's a way of altering it so we could add that maybe the professional would complete a training on 5150 holds, just so that not anybody just thinks they can do a 5150 hold and then all of a sudden they're in the middle of a crisis themselves because of what's happened. So I recommend like supporting it, but also seeing if we could add that they would do a 5150 hold training.
Isn't that part of it?
It is. It's part of it. So the bill reads that it would be an element, basically one of the three license types specified under one of this board's three of this board's license types, who is designated by the county. So the county can designate who is qualified and who is not qualified to do it. It's not worded as any LMFT can do it. You have to have a county designation.
You'd have to be certified to do that, Eleanor.
Well, I don't know if it's saying that you have to be certified. I mean, I think it would be good to be certified, but the way I heard it was that you had to have a license. So maybe I read it wrong.
You have to have a license and be designated by the county as able to do it.
Designated by the county means
Okay,
you've
that
had-
sounds good then.
got the
Yes.
training. Well, would there someone like to make a motion? Kelly.
I move to support if amended by including licensed educational psychologist under 5150A2.
Justin Huff, second.
You guys are the best.
I mean, as an aside, I don't know what they're going to do if you have a non-contract, non-county mental health professional say, take this person into custody, and it's a county mental health facility. But, you know, that's neither here nor there.
Oh, Justin seconded it already. So we're good. Any further? I agree. I appreciate that, Justin, and my colleagues. I do. We work with adults. LEPs don't work just simply with children. I have many adult clients, college aged, clients that have significant mental health issues, and I've had to have more than a few taken in for psychiatric evaluation. So I do think that, you know, the misconception that LEPs only work with school-age children needs to be changed to educate not just legislators, but everyone that you know, we work with all ages of people. So I appreciate my fellow board members. Thank you. Any further discussion from the board? Any discussion from our audience?
Leah Brew, LPCC, and counselor educator. I appreciate the support position. Many of my students who I supervise will be at a county agency, and maybe that particular agency says you have to call the police, and then the police engage in behaviors that creates more trauma, especially if their trauma already is with police. And then sometimes it's not police, sometimes it's a particular trained person with the county. They're an undergraduate level person, and I don't see how an undergraduate level person will have more knowledge about risks for suicidality than somebody who has a master's degree and a license and has jumped through all those hoops. It's a lot of my students have had to spend hours where the person who comes in to assess says, no, you don't need to go, and then work with that client to try to convince them not to commit suicide. That's where we've had the greatest amount of harm. So this is so needed. I think we are well qualified to do it, LEPs included. So thank you for the motion. I hope everybody supports it.
Thank you. Any other comments from our audience? Any comments from our remote audience?
This is the moderator, and I've opened up the Q&A feature for public comment. Members of the public, you can click the Q&A icon or use the raise hand option. All right, and seeing no requests, would you like me to close the Q&A feature?
Yes, thank you, moderator. Christina, would you please take the vote?
I had one more comment, Eleanor Uribe.
Okay, Eleanor, go ahead.
So just to reiterate, hopefully that the licensed person isn't designated at that moment. So again, a part of me just wants to say if there is an actual form that you fill out. So that's where there should be some training. But I don't want to just assume that, you know, that person has training. I just want there to be some type of cover that, you know, they will actually review it, and before the on the spot, hey, you're licensed, go do it. So that's all.
Thank you. Christina?
Dr. Nick Boyd,
Yes.
Abigail Ortega,
Yes.
Justin Huft,
Yes.
Chris Jones, Wendy Strack,
Yes.
John Sovek,
No.
Susan Friedman,
Yes.
Kelly Ranasinga,
Yes.
Annette Walker,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
Ask a quick question.
Sure.
So will Roseanne be talking with the author to help them explain LEPs, because they may not understand what LEPs do? I want them to be really, like, I don't want this to hold it up, and for them to really understand that they are qualified to do psychotherapy.
Yes, I will talk to them, and I'll have a side conversation with Chris on if they need further information.
Thank you.
Where we can point them.
I'll be more than happy to help. Item number 31 on the agenda, discussion and possible action regarding policy and advocacy committee recommendations for support Senate Bill 1012 will not be in discussion today as it has died in Senate and the Assembly Appropriations Committee. So we'll move on to agenda item number 32, discussion and possible action regarding Senate Bill 1067, Smallwood Cuevas Healing Arts expedited licensure process, medically underserved area or population. Roseanne.
Thanks, Chris. So this particular bill would require healing arts boards within DCA to expedite the licensure process to give priority review status to an applicant for a license who intends to practice in a medically underserved area or serve a medically underserved population. And we talked when we talked about a bill a few bills ago, that was another expedite bill, what some of the expedite allowances that are already in place are: military, asylees and refugees, certain things like that. I will point out that Medical Board of California already has this particular bill and have since 2013. So it's already in place, but just for Medical Board. Current law provides some definitions of a medically underserved area and a medically underserved population. And those definitions are defined in the Health and Safety Code for purposes of the California Physician Corps program, which is a loan repayment and volunteer program for physicians seeking to practice in the state. So that particular definition in the Health and Safety Code, which this bill references and utilizes, defines a medically underserved population as the Medi-Cal program and uninsured populations. And then a medically underserved area means an area defined as a health professional shortage area, as specified in a specific part of the federal regulations, or an area of a state where unmet priority needs for physicians exist as determined by the Department of Healthcare Access and Information. And both the federal government and HCAI actually have each created a database where you can identify these sites that qualify as a medically underserved area by address. So this bill, like I said, requires expediting applications for people intending to practice in a medically underserved area or medically underserved population as defined in that section of the Health and Safety Code. It states that applicants may demonstrate their intent to practice in one of these settings by providing documentation which may include a letter from a qualifying employer indicating acceptance of employment and a start date. The author's office notes that many healing arts boards have lengthy backlogs for applications, and that exacerbates the healthcare workforce shortage. They point to a 2013 bill that established this requirement for a medical board. So the definitions of medically underserved area and medically underserved population are a little bit vague. There is a database to define medically underserved area. It relies heavily on primary care physicians. So it's unclear if it's appropriate to use for all healing arts practitioners, but it is a database where you can enter an address and look something up. HCAI provides a database as well, but there's no really definition from HCAI on what is included in that, but they've made the determination, and I've provided a link to HCII's workforce database. You can look up different areas. It's unclear if that'll always match underserved areas for other healing arts professionals other than physicians, but it is a way to determine if a site might qualify, and it's pretty cut and dry. Medical Board, the way that they have implemented this bill is they use a federal website, and I've provided a link to that federal website of designated shortage areas to determine if that addresses the question. The bill also states that you can be serving a medically underserved population, and the definition of medically underserved population is very broad, and it's somewhat unclear what the threshold would be for the board to determine if the applicant qualifies. So that's kind of a concern in terms of, does that mean that you're treating, one patient that's on Medi-Cal, or does it have to be a certain number? Or if somebody asks, if they qualified, what would be that threshold that we say that you qualify for? So that would be nice information to have. Depending on how broad those definitions remain, the bill could have a detrimental impact on board processing times if the evaluators need to spend a large amount of time determining whether somebody's intended work setting qualifies for expedited license instead of evaluating applications, especially if the definition is nuanced and difficult to determine. Additionally, there are the concerns that there's numerous other possibly valid reasons to expedite, which could end up being proposals in the future. And then if we are expediting too many applications, then it really doesn't do anybody any good because everybody's expedited and so processing times stay the same. HCAI has provided recent data from the board's renewal surveys that approximately 19% of the board's registrant population works in either a federally qualified health center, clinic, or community health center. And so we believe that those settings would likely qualify for the expedite. Last year, the board processed about 16,500 applications. So that equates to approximately 3,000 applications per year that would qualify to be expedited. So that's a pretty large volume of expedites in terms of the number of applications that we receive. At the April meeting, the Policy and Advocacy Committee did not recommend a position to the bill, but we directed staff to reach out to the author's office to discuss further clarifying who would qualify for the expedite so that things were a little bit more set in stone. We would like to see some language where it was specifically pointing to whether or not it's in the federal database, because that is very cut and dry. Rather than having the applicant try to determine or having board staff try to determine whether or not something should qualify, and with all different kinds of settings out there. Anytime you get into a discussion about settings, there's very many variables and it's really difficult to make a fair determination on what should qualify and what shouldn't without clear guidelines. So this bill made it through yesterday. It made it through the Appropriations Committee, and the direction from the Appropriations Committee was to accept the author suggested amendments for the bill and move it forward. And so in attachment A, you will see what the current author suggested amendments are. It's in red ink, in the first part of attachment A. And so it's basically saying that they need to indicate that they're in a medically underserved area, indicating they serve that population and the date. And it says basically compliance does not require rulemaking. We've gone a bit further, staff has gone a bit further working with legal counsel to draft some language, and that's also shown in attachment A under board, staff, and legal suggested amendments, and that's shown in green. Those suggested amendments allow a bit more clarification that the federal database is what is to be used. So we think that there's a little bit more work to be done on this in order to bring it to something that the board can clearly implement. Staff recommends that the board consider taking an oppose unless amended position on the bill. The amendments would be the staff and legal counsel suggested amendments shown in attachment A in green. Additionally, the language would need to specify and name any and all database that the sponsor intends the board to use to determine eligibility. Because when we talk to the sponsor, the board they indicated that their intention is really that it should be an easy database lookup. That they're not intending to have it be, a complicated or confusing process. Is it in the database? Then it gets expedited. So we believe that these amendments would start to kind of move us forward to the database lookup. There are a few things about the database that I think legal has concerns with that Christy will probably bring up. She's nodding. So yes, the database, the federal database, and when we looked at some of the federal regulations, in looking at how there's a sort of a formula of percentage of things of characteristics an area has to have to qualify. And one of the things it looks at is the number of various types of healing arts professionals, but not all healing arts professionals. So some boards that are included in this bill, their professionals aren't included at all in the making of this database. Our LEPs and LPCCs are not included in the making of this database. However, the way the language is written that we've proposed, if they are working in one of these settings, they would still be, they would still qualify for the expedite if they're working in a hospital that has to be designated. But in actually the process of determining what these federally qualified settings are, certain types of professionals are not taken into consideration, which raises the question, is that the most appropriate way to do this. But nevertheless, if their intent is to have a database to look it up in and it serves underserved settings, all of our license types that are employed in these types of settings will be included, but they're not included in the making of the database. So hopefully that makes sense. I think I'm going to open it up for discussion at this point. I believe the author's office or the sponsor was going to try to attend, so they may be on in the audience. I'm not sure. So they may weigh in hopefully as well, but we'll open it up.
Motion on the.
Sorry, do we have a motion from the board on either staff's recommendation or something different? Okay, do we want to have just discussion then prior to making a motion? John?
Roseanne, may I ask you a question? This is John Sovek. Oppose with amendment versus support with amendment. What was the philosophical stance behind that?
So I think that in terms of, we're getting a lot of these expedite type of bills, and this is a very large population potentially. So I think that the concern is, you know, as these start to come through, if the board is supporting them, that's fine, but you're likely to see more. And at some point, if you're expediting everyone, then you're really expediting no one. So it's getting, and this one in particular, or at least for our board, where we're seeing HCI numbers of about 19%, it's getting a little concerning about the number of expedites we might be getting. So that's why we avoided recommending a support, but maybe if they made it a little bit clearer, be neutral. We also expect, you know, this is going to take some staff time to look up and do this. So there is a fiscal impact on the staff on this bill. And if we don't get new staff, then it will actually pull staff away from evaluating applications to go and make these determinations and answer people's questions about whether or not they apply and what they need to do to qualify and why didn't they qualify. And if we have 3,000 people calling and asking those questions, we don't have the capacity to do that level of customer service and be expediting applications.
I have questions too.
Okay. Chrissy, then Annette.
So just to add to that, you know, you kind of look at positions considering how important it is for you to get the amendments through. If it's really important, oppose is a stronger position because they respond to stick more than carrot, so to speak, in terms of changing and moving amendments into a bill. They're more interested in removing an opposition sometimes than getting support. So it just depends on whether if you don't get these amendments, how big of an impact will it be to your operations? If it's a serious impact, you probably want to do an oppose. But if you think you can absorb it, then support is another option. So just for consideration.
Annette?
Yeah, in my mind, when we reference impact, I'm always thinking of positive impact. So with that said, when according to your memo, when we look at existing law, I'm going to ask you to clarify for me under your comments on number 4. I believe it's medical board statistics. The second few lines there towards the end, the fiscal year, the medical board received roughly the same number of applications as BBS did. Approximately, you see the numbers there. Clarify what you're sharing that right there.
So medical board had 164, which is not high. When we looked at their definition of their advertisement of this program, it's relatively vague. And so it's not really out there a lot. So we think maybe people don't know, or they just haven't had the interest in expediting for whatever reason. We did share that because it's sort of a similar size, but we think that our population is much more likely to be working in these types of settings in a higher volume.
Okay, are we looking at the same reference here? Medical board statistics, the fiscal year where it references approximately 11,300 applications for the medical board versus 12,200 applications for BBS?
Yeah.
Okay, so you just use a different.
It's sort of for context of what they indicated.
So what does that mean? Does that mean that the board we're doing the work already?
No, the medical board is already doing this.
Okay, so to help me understand the reference to BBS application processing.
Just to kind of show the size comparatively where we're at, how many, their volume versus our volume. Just to show you how many applications they expedited.
And then taking in consideration, like we said, our assumption is that we will probably have a greater percentage of those to actually expedite and working in those areas than medical board.
That could be misconstrued as like, we're already working as hard as they are. We're processing just as many applications. We can't take on much more. But when we look at impact and positive impact and what we're looking at, the service we're providing, whether it's racial equity or in this situation where we're looking at, the underserved communities, we want to help. We're here to assist.
Yeah.
So I thank you for bringing back the reference of the fiscal implications. We've heard Steve mention earlier our healthy reserve and how he's looking at restructuring some areas so that we can do a better, bring on more staff to handle the volume. So I think, again, I'm hearing us today entering into conversations with a deficit perspective when we should be looking at what more we can do to assist our stakeholders and community. So again, when I hear the word impact, I'm thinking, how can we help make a positive impact? So I understand, trust me, I'm in the building. I work, we see staff. We work indirectly with them. We understand their caseloads because we have a great executive officer that's sharing with us what's happening on a day-to-day basis, but we're also here to serve. So we want to make sure that we provide the resources necessary to help the community. So if we can get more staff for you, I hear you're saying this is really not, it can be done, right? So again, I'm just trying to have a conversation that's more conducive to assisting others rather than us coming in thinking, oh my God, whoa, let's pump the brakes. Let's oppose this because it may be the words that you use here, the impact to the board, what it could be. We're not afraid of that. We're not afraid that it's going to have a detrimental impact. I wouldn't even use those words. We want it to have a positive impact where we can help make a difference. That's just the lens that I come in with. So thank you for explaining those numbers, but I think we need to have our proper perspective here and what's being asked of us to assist and help with.
And I think the oppose, what we're talking about is without the oppose, we want to, if this bill goes through, we want it, it's great, we like it, but we want to be able to implement it and not have unintended consequences. And that's what believe me, I don't like the bureaucratic, but I have to think about that. If we don't have a way to really define who we're expediting and how we actually define that, we don't want to put another barrier in there for us for processing applications, all of our applications too, as fast as possible. And if you think about it, this is going to add in a real basic level, one more step in the actually review process for us. And so I think the oppose is saying I like the idea, but we really need to make sure that we can actually implement this and we know how to implement this instead of moving forward. And if it goes through without, the amendments we're asking for, then we're probably going to come back here again to either do regulations to try to define, how are we going to implement this? And that's kind of what we're looking at. And that's why the oppose was.
And I hear what you're saying, but to me, that's not interpreted in this memo, to be honest.
Oh, okay.
That heartfelt sentiment that you just shared.
Okay.
It doesn't reflect in oppose unless amended. So
okay,
that's just my take.
Thank you, Abigail, and then Susan.
I'm just curious, how much time will people what's the time difference between being expedited versus just going through the normal process? Do we have?
So currently right now, we have two different licenses. I think I'm looking at two different applications that we're really looking at for the expedite process. I think mostly this is going to affect the registration unit. because those are the people that are registrants are getting right out of college. They're trying to get into the workforce. We want to get them in there as soon as possible. They have 90 days to practice, you know, they have the 90-day rule that helps them out. I think that there's an issue there too, though, with some counties or some agencies don't want to hire if they don't have the actual license. Currently, right now, not our busy season, we've actually are working at, it's about 2 weeks or 30 days, 2 weeks to, I mean, it's about 30 days is what our kind of maximum that we want to keep under. In busy season last year, that's what one of the issues we had. We got up to about 90 days for the registrant. Currently, right now, with the licensing process for the licensures, that's the people that are already working in these settings. They are going for the clinical exam. It got up to about 3 to 4 months. Now we're getting back down to 2 months, around 2 to 3 months. So
from the medical board that has been doing this for a couple of years now, what's I don't know, like just how much time are we saving to go through all of these new processes? Like, are we talking about a month? Like,
what process or what kind of?
if I were to be like, if I were to be expedited, right? Does that mean, I mean, if it's 20% of people, does that mean that it's gonna save me? Like, I'm gonna get registered like a week earlier, months earlier?
So the way the expedite works is basically currently you can look at our military veteran expedite. So when we receive an application for a military expedite, they get thrown in the front of the line. So depending on, I mean, how many people are expedited, I can't really say. I mean, right now it works for military, you know, it's just the time frame right now for a registrant, it would be about, I think it's 2 weeks. But if we had more expedites, yeah, that would kind of increase that would increase that time.
Okay.
But
Yeah, so we don't know, basically.
we don't really
All right.
know, but yeah.
Thank you.
Susan.
Long story short.
Roseanne, I would assume that any piece of legislation that has anything fiscally attached to it would be dead right now. Am I correct?
There are still some bills moving forward with fiscals. I think that we've given a fiscal for this bill because we would need more if the bill does not specify clearly looking up in a database, then there would be more of a fiscal impact and we would need additional staff. So we're trying to prompt the amendments to have have the language be more clear that it's a lookup in the database so that we're not having this back and forth with how do you qualify and looking for it through all of this, researching each site, because that is labor intensive. We don't know that we're going to get the positions for that in this environment. And so we want to ensure that it's something that we're able to implement. So I think that
did the medical board hire somebody to do this, or did they just
we don't know.
Go into free spin and do it?
We don't
have that information on how exactly they implemented.
Well, they've indicated they use the database.
They've indicated that they use the database,
even though it's not, you know, they use the database to verify. So that's the model that we're using to propose amendments, is to specify that the database will be the verifier. To ease it, make it simpler.
And so right now, that's what medical board uses. We would like the language to be clear that that's what we use.
And it actually makes it simple both for staff processing and for the applicant too. So,
John.
So I'd like to make a motion to support the amendment, to support with amendments. Where'd the language go? Hold on. Support with amendments, staff and legal counsel suggested as shown in attachment A. Additionally, the language would specifically name any and all databases the sponsor intends board to use to determine expedited eligibility.
Do we have a second?
Second by Dr. Walker, public board member.
Further discussion from the board? Discussion from our audience members?
Thank you. Ben Caldwell, MFT. Like Dr. Walker, I'm much more concerned with the effect on applicants than the effects on board staff. But that is why I would respectfully request that the board take an oppose unless amended position here. Board statistics already suggest that about a fifth of associates work in federally qualified health centers. A significant number are also likely, especially at the onset of their registration, to be working with other underserved populations. So many people would potentially qualify here that evaluating those expedite requests seems more likely to slow down the process overall than to really help. And that's a negative outcome here, and I don't think what any of us would want. Thank you.
Thank you, Ben. Further comments from the audience in the room? Discussion from our online participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon or use the raise hand function. And it looks like I have a couple requests. I'm going to go in the order received. First, I have Taylor Jackson. Taylor, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
And I'm the Deputy Director of Government Affairs for the California Primary Care Association. We represent the over 1,200 FQHCs, RHCs, community clinics, and free clinics in the state, and we're the sponsors of SB 1067. The bill will help us better serve and respond to the needs of our most vulnerable populations and directly benefit communities with a high level of need for greater access to healthcare. As Roseanne said, the medical board established this expedited license process, and it has been hugely helpful for our members that need it, and SB 1067 is modeled off that. In a recent survey, our members reported high vacancy rates and prolonged periods of time to fill staff vacancies for key positions. Many health centers go months with vacancies. This is a huge problem, particularly because between 80 to 90% of our patients are folks on Medi-Cal who often struggle to access the safety net services they need. Safety net providers are in an untenable and challenging position when it comes to recruiting right now. We can hire clinicians before their application is processed and cover their salaries while we wait and before we can bill for their services, which is sometimes months later. Or we can wait to hire clinicians until their paperwork is approved, which often means losing those candidates to employers who can afford to pay salaries without billing. Neither option is financially sustainable for folks serving safety net populations. Most importantly, the situation creates substantial barriers in addressing urgent behavioral health needs in our communities, because quite often our members are looking to hire a provider who would be one of only a few behavioral health providers in their area. And if their license was expedited, we can get them in the community to see patients and reduce suffering. I want to thank Roseanne and the BBS team for their willingness to work with us so far on this bill. We're committed to continuing to work with you all to fine-tune this legislation as it moves through the process, particularly around making implementation as seamless as possible. We would respectfully request the board consider a support if amended position on this bill.
15 seconds.
Thank you for your time and consideration.
Thank you.
All right. Our next commenter, Kathy Atkins. Kathy, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hi, thank you, Kathy Atkins with CAMPT. Similar to the previous piece of legislation, CAMPT is assessing this bill on the merits, which we do find a strong merit for the group that is being discussed, and we have concerns about the impact it will have on other licensees who are also trying to get their exams processed, their licenses processed. This is something we'll reach out to BBS staff independently as CAMPT tries to make its assessment, but I appreciate the dialogue and the questions to help develop our own assessment on the pros of this bill and what unintentional impacts it could have. Thank you.
Thank you.
All right, this is the moderator. Appears there's no further requests for public comment. Would you like me to close the Q&A feature?
Yes, thank you, moderator. Abigail.
Can we add a sunset date to this, or is that it's too early for that? Because I just want to further assess like if there's a positive impact. And right now, like I don't have any proof that expediting will have a positive impact out in the world. Because when I worked at FAQC and we were all licensed, like they were looking for people that were already licensed. And it was, I don't know if this will resolve the problem of people wanting to work in those communities.
Steve?
I think adding that as amendment, that's a pretty big amendment that's really going against the intent. I think we're working with, and approving or opposing with amendments is probably better, because I think if for some reason, it turns out that it's not working, then we can always, whether it's adjusting, I guess, maybe through legislation, or if we have to adjust through staff, we can figure that out. So that would be my suggestion.
Okay. All right, Christina, take the vote. And again, the motion was to support with amendments.
So was that support if amended?
Support.
With, so we're supporting and amending.
Yeah.
Yes. IF.
Typically support if amended. So that's just the way that they.
Permanent language, miss, support.
Sorry
if
about
amended.
that. I don't mean to correct.
Meant two different things. So thank you for clarifying.
And it would be the support if amended with the amendments proposed in the attachment A in the meeting materials?
Got that.
Okay.
The staff and legal counsel amendments, the second ones in green text.
Correct. Thank you.
Dr. Annette Walker,
Yes.
Kelly Ranasinga.
Respectfully abstain.
I'm sorry, say that again.
I respectfully abstain.
Thank you. Susan Friedman,
Yes.
John Sovic,
Yes.
Wendy Strack,
Yes.
Chris Jones,
No.
Justin Huft,
No.
Abigail Ortega,
No.
Burnett Boyd,
No.
Eleanor Uribe,
Yes.
motion carries.
Thank you.
So how many yeses were there and how many nos? 4 nos and. Yeah, so we don't count the abstention. We only count the affirmative votes. So how many affirmative votes? How many yeses and how many nos? So there were 5 yeses and 4 nos. Okay, yeah, then it does pass this. Correct. Sorry, just want to double check. All right.
All right, thank you. There's 10 of us. 1, 2,
Okay,
3,
so abstentions are like you don't cast a vote.
So there's 9 votes total, because
One
there's
was an
10 of us here.
abstention. So there was a 4-4. Then it didn't pass. If there's 2,
No, Eleanor who's online.
and she voted yes.
Yes, she voted yes.
Okay, so there are 5 yeses then. Okay, I'm just. Okay, so just a real quick recap on votes. So if you abstain, we don't count it. We only look at the affirmative votes. So it's whichever one has the most affirmative votes. Okay.
All right, thank you. Next on the agenda, item 33, update on board-sponsored legislation. Senate Bill 1024, Ochoa Bow, Healing Acts, Board of Behavioral Sciences licensees and registrants, and Senate Bill 1526, Senate Business Professions and Economic Development Committee, Consumer Affairs. Roseanne.
Okay, so these are our 2 bills that we're sponsoring a portion of this year. We've already talked about amendments to SB 1024 today. That particular bill has passed through the Senate and is now in the Assembly. The other bill, SB 1526, the omnibus bill proposal, the board has one minor technical change in that proposal this year. And that bill has passed the Senate and is now in the Assembly as well.
Thank you. Any comments from our board? Any comments from our audience? Any comments from our remote participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon or use the raise hand function. All right, and seeing none, would you like me to close that Q&A feature?
Yes, thank you. Next on the agenda is get transition lenses. Item 34, discussion and consideration of comments received during the 45-day public comment period and proposed responses thereto for the board's rulemaking to amend California Code of Regulations and adoption of amendment to all of those sections. Christy, this is yours.
Hi. Hi, thank you. Can you hear me okay?
Yes, thanks.
Great, thank you. So this pertains to the board-approved regulatory changes for its unprofessional conduct regulations. These were fairly minor changes that would result in striking some regulations that duplicate statute and would also provide for transparency by adding references related to the Confidentiality and Medical Information Act. The originally approved language is in attachment A. The proposal was noticed to the public for comment on February 2nd. And so we did receive one public comment from CAMPT, and that is providing attachment B. But to summarize their complaint, their concern is that there's an inconsistency that could be perceived in that originally approved text between subsection B and renumbered subsection D5 of 1886.40, because subsection D5 states that the board may assess fines not exceeding $5,000 if the violation includes an unlawful or unauthorized breach of confidentiality. And then subsection B states that the fine for violating the Confidentiality of Medical Information Act shall not exceed the amount specified in 5636 of the Civil Code. So CAMP was concerned this might cause confusion as to whether the fines involving these types of violations would be assessed at the maximum amount specified in subdivision B or at the maximum amount in D5. So if you look at page 7 of the proposed language, we've added a couple of clarifications to the language. So it's shown in double underline on page 7. So basically just providing clarifications. So that except as provided in subsection B for citable offenses where the citation alleges a violation of the Confidentiality of Medical Information Act. So just clarifying.
Chrissy, we lost you.
Oh,
Chrissy,
you did?
You're all of a sudden muted. We're not hearing you.
Oh, no.
So you got to the point where you said subsection B and then cut out.
Okay. Can you hear me now?
We can, yes.
Okay, great. Not sure what happened there. Anyway, so basically the proposed language, the amendments to the proposed language that are here for the board's consideration are on page 7. It's just adding some clarifications to ensure that there's no confusion about that, the fine amount. So if I'll open it up for discussion. We do have a recommended motion. If the board wants to go ahead and accept these proposed changes.
I will motion to accept the proposed changes. Do we have a second?
I can read the motion.
Sure.
Okay. The motion would be to approve the proposed responses to public comments received, approve the proposed amended regulation text for section 1886.40, and initiate a 15-day public comment period. If no relevant adverse comments are received during the public comment period, authorize the executive officer to make any non-substantive changes to the package and take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections 1845, 1858, 1881, 1886.30, and 1886.40 as noticed.
I will move. Do I have a second?
Kelly Renisinger, public member, I second.
Discussion from our board. discussion from our audience in the room?
Hello, Shanti Ezrin with CAMP. Just wanted to thank staff for the added clarification in response to our comments. Thank you.
Thank you. Comments from our remote participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, you can either click the Q&A icon or use the raise hand option. All right, seeing none, would you like me to close that Q&A feature?
Yes, thank you. All right, Christina?
Dr. Annette Walker,
Yes.
Kelly Ranasinga,
Yes.
Susan Friedman,
Yes.
John Sopek,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
Justin Huft,
Yes.
Abigail Ortega,
Yes.
Dr. Nick Boyd,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
All right, our next item up on the agenda is the update on board rulemaking proposals. Christy?
Yes, so the disciplinary guidelines, well, actually, I'll start with unprofessional conduct, which we just covered. So what will happen next is I'll take these changes that you all have approved, and we'll do a notice of modified text. So the public will have an additional 15 days to comment. If there are any comments, we'll have to bring those back to the board for consideration as well, if there's any relevant comments. If not, then we'll keep proceeding through the regulation process. The disciplinary guidelines has been submitted now to the Department of Consumer Affairs, Office of Legal Affairs, to begin their review process in the production phase. So there's sort of like two initial phases with DCA. So, but it's off into the races. So I'm very excited about that one. And then the other board approved regulation proposal is the telehealth regulations. So I'm going to begin working on that. I just had a few other things I had to that I'm working on right now. Then I'm going to circle back to regulations. And that will not take me nearly as long to prepare since it's a more simple regulation change. So, and that was that.
Thank you. Any comments from our board? Comments from our audience? Comments from our online participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, you can click the Q&A icon or use the raise hand function. All right, seeing no requests, would you like me to close that Q&A feature?
Yes, thank you. All right, board, we're at an hour and a half of sitting. Do we need a few minutes to stretch legs before we move to the rest? Is that okay? Yeah, everyone's all right. Let's take 5 minutes. We'll take 5 minutes. Stretch. All right, next on our agenda is item 36, overview of the board sunset review. Steve, would you please provide us with the overview?
Yes, I would be amiss if I didn't notify you guys that we're actually going to be preparing for the sunset review for next year. So this is what this overview is about. Every year, selected boards and bureaus must submit detailed reports to the Assembly Committee on Business and Professions and Senate Committee Business Profession Economic Development. It's a joint committee for the legislature. We need to prepare sunset reports, and these reports combined with committee staff reports form the basis for public hearings that will occur next year. These hearings offer stakeholders a chance to provide feedback on the performance of the board and the bureau. So each board has a sunset date in its authorizing statute, and without legislative action to extend this date, the board would cease to exist. We don't really want that to happen. So if a board is found to operating satisfactorily, usually the committee proposes legislation to extend the sunset date, usually by 4 years. If not, then they can do a lesser amount of years, or there may be significant changes to the program itself. asked for the program itself. So our last sunset date was on January 1st, 2020. And due to the COVID pandemic, the sunset hearings were delayed till 2020, resulting and in 2021, we finally got a 4-year extension, which extended our sunset date out to January 1st, 2026. So we will be needing new legislation in 2025 session to extend our existence beyond that point. And this legislation is typically sponsored by the Senate Committee on Business and Professions and Economic Development. So the board's actual sunset review is a document, and it's a comprehensive document addressing questions about our operations and performance and some past issues or issues that we had experienced in the past 4 years. So it will include statistics and procedural information, and it'll detail all the work we've done since 2021. And a draft report, we will present a draft report in our, actually, September meeting. Wow. I was going to say something in July or August, but September meeting, which, thank gosh, it gives us a bit more time to actually put together some more. So the goal is to provide that comprehensive report in September as a draft version. You'll have the chance to review it, and then we will finally approve that schedule in November, approve that actual report in November meeting, because that has to go over to the legislature in December, I believe. So at the end of the year. And then after that is presented, what usually occurs is we'll get questions from the legislature on issues that they want us to address, or questions they have about our actual board, and we will draft responses to those. Those will be brought to the board to look at, to approve, and then we will have a hearing date where usually it's the board chair and myself will go in front of the legislature to answer any questions that they have about our board, and then hopefully they will approve us for an extension. We've been successful for the past few years getting a 4-year extension, so hopefully they will see, they'll see that again. So I just really, there's not much to offer you on the sunset report and what we're doing right now. I did put in there kind of the outline of what we're working on that kind of gives you an idea of what the format will look like. You can actually see our last sunset report, and there's actually an addendum to that one because of the COVID situation. You can see that online. So I would recommend, if you are interested in seeing what it looks like, please check that out. And then in September, we'll present a draft. Any questions?
No questions? Any questions from our audience? Any questions from our remote participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you'd like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and seeing no requests, would you like me to close that Q&A feature?
Yes, thank you. Moving on to item 37 on the agenda, discussion and possible action regarding diversity, equity, and inclusion supplemental strategic plan draft language. Steve, the floor is yours.
Excellent. During our last board meeting, February 2024, the department's Solid Office hosted a strategic planning session during the board meeting, and this session aimed at taking a review of the board's strategic plan. It's the 2022-26 strategic plan, with a particular focus on assessing the diversity, equity, and inclusion impacts of policy decisions. And this review included considerations of regulatory, statutory, and continuing education requirements. Attached, I have to the materials is a draft version of the board's 2022-26 strategic plan, which includes the amendments discussed during the session. And additionally, Solid had made some suggested edits to the proposed amendments for the action items below during their review, and I believe those are included actually in the amendments. As you see, they're kind of just wording differences. So they made a change to stakeholders to other stakeholder groups. Following, there was a question about the word proportionality. So they had suggested removing bias as has been done here. We also suggest the objectives start with review rather than complete, and that was for 3.3. And also, we made the mentions of IDPs, and those are individual development plans. And they suggested changing that with performance evaluation, which I kind of agreed. I thought it was a good change. So some of the additions you can see they're in bold language in there. And those were what we had come up with. So just would like to open that up to see if everyone is okay with the suggested changes or if there's any comments or suggestions. Let me get my notes.
Would anyone like to make a motion to recommend or to adopt the changes?
Before we do that, just a clarifying question. So
Absolutely.
this is the work that we did in the workshop. Okay.
Correct, yeah.
And we went and cleaned it up. Okay.
Justin Huff, I motion to accept these changes.
Excellent. Do we have a second?
Dr. Walker, Public Board Member, I'll second.
Further discussion?
I think you're missing, sorry, Kelly Renner-Singer, Public Board Member, in 3.3. I think you're missing a 2. It's review and make recommendations as necessary to the board's existing enforcement statutes and regulations to ensure clarity, proportionality. I see their points about bias because it seems to add an emphasis, but no, that's, yeah.
So you're suggesting review and make recommendations as necessary the board's existing enforcement statutes and regulation 2 or?
No, as necessary to the board's existing enforcement statutes and regulations.
Oh, I see what you're saying. Okay. Okay. If everyone's okay, if I make that change?
Recommendations as necessary.
I don't know, I'm reading it. It says review, and if you just ignore the and part, it's review the board's existing enforcement statutes and regulations to ensure clarity, proportionality, cohesiveness, and equity. So review and make recommendations to existing statutes and regulations as necessary?
No.
No.
Necessary to.
As necessary to the board's existing enforcement statutes.
Oh, so
and
delete the
regulations.
comma there?
Yeah.
Okay.
I mean, I suppose you could read it like that, but.
Yeah, so
The 2 commas already. Oh, or we can move it to the end. That
Yeah.
make recommendations as necessary, just move that. to the
Yeah.
end.
Yeah.
I think that makes.
make that to the, put
better
that to
that
the
way,
other,
probably.
okay.
Sorry, are you guys on 6.2?
3.3.
3.3.
I have some feedback when you're ready.
So you suggest, so review the board's existing enforcement statutes and regulations to ensure clarity, proportionality, cohesiveness, and equity, and make recommendations as necessary?
Yes, I think that's much better.
Yeah, there you go.
John disagrees.
Wait, what?
Well, the word and.
To ensure clarity.
Yeah.
Okay, I see what you're saying.
I think they're gonna.
If you're using an
True, yeah.
Or do you say and equity, comma, make recommendations as necessary?
Oh, yeah, let's,
Hold on, wait, you gotta slow down. You gotta slow down. Our note taker, we needed one person at a time, so let's back up.
Mm-hmm.
So could you say, review the board's existing enforcement statutes and regulations to ensure clarity, proportionality, cohesiveness, and equity, comma, making recommendations as necessary?
Okay.
That works.
Does that
Okay, you do that.
Yeah.
So do we have the grammar police member? Eleanor, okay.
I have more. These are just suggestions. I know it was in 5.5. It said something about individual developmental plans. I actually kind of like that, that wording only because it does sound more, it sounds supportive and like it's like professional development and it sounds more voluntary versus performance evaluation almost sounds more involuntary. That's just a suggestion. Let me see what else I wrote.
I'm not, what was your suggestion, Eleanor? I
Okay,
heard that
so
you liked it, but I didn't hear. Yeah.
5.5, I'm trying to follow myself. So 5.5, increase employee engagement and job satisfaction by creating a more inclusive approach to individual development plans. And I think the recommendation was to change it to performance evaluations. But I was just saying, I kind of like the idea of individual development plans because that I felt like that sound more voluntary and it sound more supportive.
So
Go ahead.
As it's written in the bold is the recommended changes. Yes?
Well, it is the recommended changes, but before it said, no, actually, they're
Evaluation.
making a suggestion to put, they're putting
Performance evaluation.
performance evaluation is what
Right.
they're suggesting.
Right, but IDPs are required in state service. That's why it says individual development plans, because that's actually a requirement in civil service that we each have individual
true.
development plans that are reviewed by our supervisor. I think it was annually. I haven't had one in 15 years, but I think you're supposed to do it annually, right? That's my
Yeah,
recollection.
you're supposed to do it annually or I think what they're, because the individual development plan is actually, there's a component of that where I think the IDP, you have to do the performance evaluation, and IDP is actually a voluntary. If the person wants to see their individual development plan, they craft that with their supervisor. But a performance review is kind of a mandatory thing, if I'm correct.
Because weren't you
Because the
saying, weren't you saying this is voluntary?
The IDP is.
Uh-huh.
So I think that's what they're
Is
trying to get at. So,
Is 5.5 required?
so 5.5 is the what we're looking at as possibly a goal. The IDP itself. So there's a question between IDP and a performance review. Performance reviews are required. IDPs are something a staff member can volunteer to do with their supervisor.
Okay. Well, anyway, I'm not sure if I totally understand that process, but I was going to say if it's voluntary, then the IDP sounds better. For number, I think it was 6.2. Go to that. I thought it was a little oddly stated. Collaborate with entities that work with consumers to increase equitable and inclusive outreach to diverse populations. What stood out? I'm trying to think. Can't think right now what stood out. 6.5, I felt maybe if we could use, so it's increase awareness to the profession by using outreach to build relationships. So instead of saying outreach, maybe partnerships with underserved communities.
I think we might have actually talked about that, and outreach is really what in our purview. Although we want to definitely, partner and create relationships with them, I think outreach really speaks more to what we can actually do as a board.
Those are just suggestions.
All right, thank you. Any further comments? Comments from our audience? Comments from our remote participants?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, you can click that Q&A icon or use the raise hand function. All right, seeing none, would you like me to close that Q&A panel?
Yes, thank you. All right. Christina, will you take a vote?
Dr. Nick Boyd,
Yes.
Abigail Ortega,
Yes.
Justin Huff,
Yes.
Chris Jones,
Yes.
Wendy Strack,
Yes.
John Sovic,
Yes.
Susan Friedman,
Yes.
Kelly Ranasinga,
Yes.
Dr. Annette Walker?
Yes.
Eleanor Uribe?
Yes.
Motion carries.
All right, thank you. Next on our agenda, item 38, suggestions for future agenda items. Are there any future agenda item suggestions from our board members?
I'd like to
We'll get to the audience in a moment. We'll start with our board members. Thank you.
I would like to propose to revisit the student trainees and the 90-day review policy that currently exists. I think I mentioned this back in the October board meeting. I'm not sure, when we can get to it on our agenda, but I do think it's something I would like to see happen sooner than later, if we could at least have a conversation about that. Specifically, the number of student trainees operating and practicing without a license in the state of California. Currently, there's 25 in-state MSW programs, roughly 44 clinical mental health counseling programs, a number of out-of-state training programs that have students practicing in our state. And as a board, we have no idea who they are, what they're doing, who's supervising them. And I would hope that the board takes that as seriously as they took with their discussion about the interstate compact in terms of consumer protection, because I think that's in parallel to the conversation we had.
All right, thank you, Nick. Justin.
Justin Huff. I want to also reintroduce two topics that I've brought up before. One is the board's purview and possible regulations around supervision pay. And in particular, I'm hoping that board staff can come to future meetings with a summary of what other states are doing or perhaps what other boards are doing to possibly regulate exploitation from supervisors. And the second topic that I am also echoing previous requests for is to talk more about this online gig economy therapy world that is happening, that it seems like we are all trying to grapple with how best to deal with that, but the board has yet to officially speak to that, and I'd like to see that happen.
Thank you. John.
And in regards to the two comments that were just made, for a while there, Steve, we had a part of your report about action on future agenda items that were proposed at these meetings, and that seems to have slipped out of our reporting energy. So I would like to invite it to come back in. Do you remember? Okay, cool. Thank you.
All right, Susan.
I would like to just explore ways that we can perhaps ourselves be involved in getting more people to become therapists, because we know that there's a huge shortage right now. And we actually don't know where it is. Steve and I were discussing this, because it could be way up north. It could be way down south. We just don't know where the shortage is. But perhaps we could ourselves be out there talking to schools, talking wherever the staff thinks would be an intelligent place for us to be, to talk to young people about becoming therapists, because of this incredible shortage that we have in the state right now.
All right, thank you, Susan. Kelly.
I'd like to agendize an item for the next board meeting. I would ask the CEO to provide a very brief report on whether or not enforcement has picked up on our probationees having a difficult time in the latter stage of probation because of the financial costs associated with it. We've heard that, I think, in every single hearing we've had, is that the primary reason that people come for early termination of probation is because of that very powerful negative effect of probation costs. I'd sort of like to know whether enforcement is hearing that as well. And then if they're not, great. If they are, then I think we can further agendize an item on it.
Thank you, Kelly. Sure.
Are you talking about testing?
All costs, because interestingly, the fees for probation are, I wouldn't say they're minimal, but they're less than the costs that the probationers are speaking about in the hearings. So one probationer said it's going to cost $4,000 over 4 months. Another probationer said it's going to cost $6,000. But that doesn't equate to the annual fee of probation. So I'm wondering why they're saying that.
All right. Thank you, Kelly. Any other agenda items from our board? We have agenda items from our public.
My name is Jeff Embler. I'm here today to advocate for friends and family who are ASWs working toward their LCSW. First, I want to thank Steve. We've had several conversations by phone and email, and he's helped me with some Public Records Act requests. He's always been very helpful and responsive. In the past, the board has expressed, including today, expressed interest in removing barriers to entry for therapists. So I want to bring an important matter to your attention. Last year, the board staff changed interpretation of how many units of supervision ASWs are required to have for their clinical work. The short version is, if you look at an ASW weekly log of experience hours, they move what I'll call the 10-hour trigger, where after 10 hours of practice, a second unit of supervision is required from column A1, which is face-to-face psychotherapy, to column A, which includes a host of other activities. This has the effect of doubling the burden of supervision for ASWs. That means double the cost because most have to pay for supervision, double the time getting supervision, which is more time away from helping clients, and yet another obstacle to licensure because finding LCSW supervisors can be difficult. ASWs only learned about this change when it was implemented through Track Your Hours. This enormously impactful policy change, while I'm sure well-intentioned, wasn't publicly announced and wasn't discussed in public board meetings. It's evident from emails the board received from ASWs and even LCSW supervisors how widely understood the previous interpretation was. That previous interpretation was itself a de facto regulation, even if it was later regarded as a so-called misinterpretation. That means any changes should have gone through a standard regulatory process. I urge the board to reconsider this change and to do so in a public setting with engagement and input from the clinical social worker community. Thank you.
Thank you.
I've been Caldwell, MFT, and just to kind of revisit comments from Board Member Sovek, Board Member Ranasinghe. We had talked some time ago about the possibility of doing some kind of a larger holistic look at the board's disciplinary processes and how well they are actually serving the intention of bringing people back into good standing with the board. Some data that was provided to me months ago, Steve, I think you gathered that, so thank you, suggests that the majority of people who are put on probation by the board do not actually successfully complete that probation. If that is the case, it is worth understanding the reasons why people are either reoffending or simply choosing to give up on the process. So I would love to have that as a holistic conversation about the disciplinary process at a future meeting. Thank you.
Thank you, Ben. Any further agenda item suggestions from our audience? All right, how about from our remote participants?
This is the moderator. In the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make suggestions for future agenda items, please click the Q&A icon or use the raise hand function. All right, and seeing no requests, would you like me to close the Q&A panel?
Yes, thank you, moderator. Next item on our agenda is number 39, public comment for items that are not on the agenda. I will now open for public comments for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. Each commentator will have 2 minutes. Do any of our board members have any comments that are not on the agenda? All right, Ben.
Ben Caldwell, MFT. I know this comes up a lot, and I wonder if the board needs something on the website, or if Steve, you could give just a quick sentence about it, because questions just keep arising about it. If there was some way that you could help make people aware of the board's current practice related to the acceptance of electronic signatures, even just as a standing item as part of the executive officer's report at each meeting, because those questions do come up on a common basis. Thank you.
Thank you, Ben. Any other comments from our audience? Any comments from our remote participants?
This is the moderator. At the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment for items not on the agenda, please click the Q&A icon or use the raise hand function. It looks like we have a request from Kenneth Edwards. Kenneth, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, everybody. Can you hear me?
Yes, we can hear you.
Great, great. I wanted to say a very, very quick hello. I'm so sorry I couldn't be there with you, but I wanted to say thank you to just all of the people in the room. This is my last, probably about 4 weeks with CalPIC, and I just wanted to sign in. I'm sorry I couldn't be there, but thank you, Steve. Thank you, Roseanne, Christy, the rest of the team, and the board there at the BBS. Dr. Nick Boyd, thanks for representing us well, and Dr. Leah Brew, I know, is there. GV is in the room, and thank you, Dr. Caldwell, Kathy from CAMP, thank you, NASW. I just wanted to say thank you to everyone for all of the support that you've shown me over the last many years since Dean has set the foundation for the LPCC. Even though we didn't have a win today, we've come a long way from the days of no LPCC to AB 462 and so many things. But I wanted to say thank you, and sorry I can't see you and I can't be there, but I wanted to just give a heartfelt hug. And CalPIC will be having a new executive director very soon. We don't have an announcement just yet, but please reach out and thank you.
Thank you. I'd like to, Kenneth, and thank you. I can't see you. I wish we could see you and say this in person, but no, we really appreciate all the support and the really great partnership that you've been working with us over the years. It's been very appreciative. We're sad to see you go, but I'm sure you're leaving a good legacy behind, so you've got things going good there. But no, just a really heartfelt thank you for your support and your collaboration over the years. It's greatly appreciated.
And this is Rosie. I'd just like to add on to that, Kenneth, you're going to be greatly missed. Thank you. You were just such a pleasure to collaborate with you and work with you. And please stay in touch. You're going to be greatly missed.
Oh, you all are the best. I thank you. You're going to make me tear up here. I'm in Southern California, but I have to smile because I'm here. Right, that's what people do here. But thank you so much, everybody. And if I forgot a name, I'm so sorry, but know that I'm thinking about you too.
No, thank you.
Right. Thank you, Kenneth.
All right, this is the moderator. Appears there's no further requests. Would you like me to close that Q&A panel?
Yes, thank you, moderator. And with that, we come to our final agenda item, which is adjournment. Thank you for participating today. I hope to see you all at the next board meeting that will be held on September 19th and 20th.
Board Member Jones? Yep. I'm sorry. We have neglected to mention something. It appears that our executive officer did not mention that he too received a 25-year award from the Department of Consumer Affairs.
What? Oh, congratulations, Steve. Did you get the watch, the plaque, the bracelet?
I got a humongous clock.
A clock.
I don't know why.
Excellent. Keep everything on time. Well, congratulations. That's great. All right. And that is the best thing to end this meeting on. It is 4:23. This meeting is adjourned. Thank you so much. We'll see you in September.